communications and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. B, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to all communications with the White House, Department of Defense, and the Office of Management and Budget, as well as the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance to Ukraine, including all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. C, all documents, communications, notes, and other records created or received by Secretary Michael R. Pompeo, Counselor T. Ulrich Breckbull, former Special Representative for Ukraine Negotiations Ambassador Kurt Volker, Deputy Assistant Secretary George Kent, then United States Embassy in Ukraine Chargé d'Affaires William B. Taylor, and Ambassador to the European Union Gordon Sondland, and other State Department officials relating to efforts to 1. Solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations. 2. Schedule, cancel, or withhold a White House meeting for Ukraine's president. Or 3. Hold and then release military and other security assistance to Ukraine. D. Any meetings or proposed meetings at or involving the White House that relate to Ukraine, including but not limited to 1. President Zelensky's inauguration on May 20, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and the subsequent decision about the composition of the delegation of the United States. 2. A meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine Negotiations Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3. Meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andriy Yermak and Alexander Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, and Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and a subsequent meeting in the wardroom. 4. A meeting at the White House on or around August 30, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5. A planned meeting, later canceled in Warsaw, Poland, on or around September 1, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6. A meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney, concerning the lifting of the hold on security assistance for Ukraine. E. All communications, including but not limited to WhatsApp or text messages on private devices between current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, and the following: President Zelensky, Andriy Yermak, or individuals or entities associated with or acting in any capacity as a representative, agent, or proxy for President Zelensky before and after his election. F. All records specifically identified by witnesses in the House of Representatives impeachment inquiry that memorialize key events or concerns, and any records reflecting an official response thereto, including but not limited to 1. On August 29, 2019, cable sent by Ambassador Taylor to Secretary Pompeo. 2. An August 16, 2019, memorandum to file written by Deputy Assistant Secretary Kent, and 3, a September 15, 2019 memorandum to file written by Deputy Assistant Secretary Kent. G, all meetings or calls, including but not limited to all requests for or records of meetings or telephone calls, scheduling items, calendar entries, State Department visitor records, and email or text messages using personal or work-related devices between or among 1, current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, and Ambassador Sondland, and 2, Rudolph W. Giuliani, Victoria Tensing, or Joseph DeGenova, and H, the curtailment or recall of former United States Ambassador to Ukraine, Marie Masha Yovanovitch, for the United States Embassy in Kiev, including credible threat reports against her and any protective security measures taken in response. And 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
The Senate clerk reading the amendment offered by Senate Democratic Leader Chuck Schumer to the impeachment trial organizing resolution.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 10-minute recess before the parties are recognized to debate the Schumer amendment. At the end of the debate time, I'll again move to table the amendment as the timing of these votes are specified in the underlying resolution. So I ask consent that the Senate stand in recess subject to the call of the chair.
Without objection, the Senate is in recess.
Well, we've seen the first votes in the Senate impeachment trial of President Donald Trump, a vote to table the First Amendment proposed by Senator Chuck Schumer, the Democratic leader, which would have sought testimony and evidence on the hold on aid to Ukraine. Another Schumer amendment is pending. You heard from the Majority Leader, a 10-minute break. And here on C-SPAN 2, we're going to open up our phone lines for a brief bit here and hear from you, 202-748-8920. If you're a Democrat, that's 202-748-8920, and then 202-748-8921 for Republicans. All others use 202-748-8922. And if you would like to text us, that'd be great. Send us a text at 202-748-8003. If you do that, make sure you tell us your name and where you're texting from. Craig Kaplan is our Capitol Hill producer in the Senate gallery, watching all of this, tweeting this just a few minutes ago about that first vote. 53-47, the Senate tables the Schumer amendment to subpoena relevant White House documents and records involving Ukraine. I'd vote along party lines, he said. And the amendment we see coming up, the amendment that's pending now, we just heard some opening remarks, the clerk reading that amendment, Schumer offering a second amendment to subpoena certain State Department documents and records involving aid to Ukraine. While we wait for your phone calls, just a little bit of the argument we heard earlier. First from one of the House managers, Zoe Lofgren of California, and she becomes the first female House manager to speak in a Senate impeachment trial. And then we'll hear from the Deputy White House Counsel, Patrick Philbin, and get to your phone calls.
This is C-SPAN Radio, simulcasting C-SPAN 2 television.
Trial without all the relevant evidence is not a fair trial. It would be wrong for you senators acting as judges to be deprived of relevant evidence of the president's offenses when you are judging these most serious charges. It would also be unfair to the American people who overwhelmingly believe the president should produce all relevant documents and evidence. Now, documentary evidence is used in all trials for a simple reason. As the story goes, the documents don't lie. Documents give objective, real-time insight into the events under investigation. The need for such evidence is especially important in Senate impeachment trials. More than 200 years of Senate practice make clear that documents are generally the first order of business. They've been presented to the Senate before witnesses take the stand in great volume to ensure the Senate has the evidence it needs to evaluate the case. Now, documentary evidence in Senate trials has never been limited to the documents sent by the House. The Senate, throughout its existence, has exercised its authority pursuant to its clear rules of procedure to subpoena documents at the outset of a trial. We don't know with certainty what the documents will say. We simply want the truth, whatever that truth may be. So do the American people. They want to know the truth. And so should everybody in this chamber, regardless of our party affiliation.
It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone.
That is Deputy White House Counsel Patrick Philbin making his argument against the amendment proposed by Senator Schumer. Zoe Lofgren, one of the 7 House managers, speaking in favor of that. The Senate tabled. They blocked that amendment along party lines. The vote was 53 to 47. They should be back within 10 minutes here and vote on yet another resolution. These resolutions are proposed changes to the rules by which the Senate will be guided during the rest of the impeachment trial. And in the coming minutes here, we'll see a vote likely on blocking it or tabling it. The amendment would allow for testimony and evidence from State Department witnesses. Getting your thoughts and reaction, numbers are on your screen. We'll go to Chase in Cincinnati on the independent line. Thanks for waiting.
And those numbers again, Democrats 202-748-8920, Republicans 202-748-8921, and others 202-748-8922.
Thank you. I appreciate you taking my call. I'm hugely troubled by what I saw today. I mean, I saw 53 people blatantly just disobey, just completely break their oath in front of the American people. I mean, this was documents, witnesses. These are things that you should want to be able to want to hear. And I just think this is a sad day for America, including Senator Rob Portman in particular.
And keep in mind, under the existing rules proposed by Mitch McConnell, his proposal is that the Senate will address the issue of documents and witnesses after all of the arguments have been made by both sides and senators have asked their questions. That be later in the process. Juneau, Alaska, we hear from Becky on the Republican line.
Hi, I'm glad we have checks and balances, and it's being put to the test for all the world to see. And that's a good thing. Our Constitution is strong, and it's a Constitution that other countries want. And this is a perfect example of how we come to the truth by having an organized, controlled environment. And I just like to say that the House has the right and responsibility to prove the facts that they say that they have that are completely obvious and overwhelming. And if that's not the case, then this should be dismissed as a farce, and it should be shown that the Democrats want to overthrow our standing president, which is a very serious matter.
Thanks, Becky. If you want to text us, 202-748-8003, include your name, where you're texting from. This one is from Thomas here in Florida. He says they should allow witnesses now. They should allow more documents and don't waste our time on Biden's. They have nothing to do with Trump crimes. Vicky in Wichita, obvious of the attempted overreach of the Democrats. They are guilty of abuse of power. So we go to Max next, Democrats line in Lisle, Illinois. Max, go ahead.
Hi. So I do feel like today was kind of a dark day for politics. You know, this is not what I expect any member of the Senate to represent the will of the people as. It's pretty, sad and depressing. I think that they have a responsibility to uphold the Constitution and hear, if this is a trial, they need to hear witnesses and evidence. I don't know why they're so eager. It seems like they're trying to push past a lot of the process that they're claiming they're not getting. If you want due process, then let the process roll out. And that's pretty much it.
Okay, Caleb, next up, Independent Line. Independent Line, and Caleb is in Pine River, Minnesota. Hey there.
Hi, how are you? Thank you for taking my call. I think, honestly, when you look at it, when you look at the House and then you look at the Senate, I think the Republicans they were basically undermined the whole process. And honestly, when you look at it, you see Schiff and Nadler, the way they conducted themselves in those meetings are just, it's crazy for me as an American to sit there and think that's okay. And then when the Senate Majority Leader Mitch McConnell comes out and says what he wants, rule setting, and I think it's a great idea, because if they're not going to give us a fair trial, why would we want to give it back? And then having the couple weeks, about 3 weeks, where Nancy Pelosi didn't even give over the impeachment documents, I think that's insane. And if they're saying Donald Trump is abusing power, then Nancy Pelosi should be on that list too, because she should not be able to do that for about 3 months. And that's all I got to say. Thank you.
We'll go to Wayne in Natchez, Texas, next up on the Republican line. Mike in Hatfield, Pennsylvania. Jumped ahead of you there. Go ahead, Mike, in Pennsylvania.
No problem. Great show. Let me just say at the outset, I'm just another partisan hack. So let's clear that right up. Having said that, let me make 3 points. I think that it's a little disappointing on the Democrats' behalf to get to the party and they're pretty much empty-handed. I mean, we heard nothing but how they had overwhelming evidence. You know, it was going to shock the world. And, you know, they show up and it's like zero. You know, it's just speeches and some lectures and some pleading and some begging and basically saying, guys, you know what? We have all this stuff. We have all this proof. We have all this evidence. But you know what? Could we ask the Senate to kind of bail us out because we don't really have a case here? I mean, that kind of sort of is obvious to me.
All right, let's take a look. A couple of texts coming in. This is 202-748-8003. Lee from Texas says, awesome job, Republicans. Micah from Dallas saying, I'm actually shocked at the dearth of charisma on Trump's legal team. San Francisco next up to our Democrats line. Isaac, hi there.
Yeah, I'm calling because I'm just saddened about this day that we're having to deal with, this sad day where our country is our Senate is being divided now, where the Republicans are saying that they don't want the Democrats to have their witnesses and their information that they want to show what the president has done, and it doesn't surprise me that the president didn't want to defend himself. He tends to do it on Twitter, which is not a place to defend yourself. If he's going to defend himself, he needs to show up in person and do it, and he's scared to do it. And I'm glad that Nancy Pelosi took a while to give the stuff to the Senate, because she was doing the right thing by holding it and sending them a message that they can't, that the Republicans in the Senate have to come up with what they need to come up with before she can send the stuff. And I'm glad that the senators that are running for president are taking time out of their presidency, they're taking time out of them running for president to do this, because they need to defend this country, and they need to do that. And that's all I have to say. Okay,
Isaac. What you're seeing on the screen is what's called the slate from the Senate. Keep in mind those cameras are from the U.S. Senate. They're not C-SPAN cameras. We're waiting for the members to gavel back in. The leader, Mitch McConnell, saying it'd be a 10-minute break. It's been a little bit longer than that. Here with some video, too, there from outside. That is actually in the down below in the Senate, the basement of the Senate. We'll listen in.
The Senate Minority Leader, Chuck Schumer. This is C-SPAN Radio, WCSP-FM, Washington.
How unfair Leader McConnell's resolution is, and they are telling Republican senators to change it. We're very glad they moved to 3 days instead of 2, so we won't be hearing arguments at 2 in the morning. It's good they admitted evidence, but the real test will be witnesses and documents. Will our Republican senators pressure McConnell so that we really have witnesses and documents produced, either now or after the arguments are made. And one other point, I'm not answering questions. One other point, which is this. We hear a lot of arguments from the President's counsel. None of them directly address why there shouldn't be witnesses and documents. They talk about how bad the House is. I don't agree with that at all. But they don't argue, one, they don't make a single argument why there shouldn't be witnesses and documents. That speaks volumes. Thank you.
And Senator Schumer likely headed back upstairs to the Senate floor. His previous amendment defeated 53-47. It was blocked, tabled by Republicans, would have called for witnesses and documents relating to Ukraine aid. Another pending amendment deals with State Department documents and records as well. We'll continue to take your phone calls till the gavel comes down in the Senate. In Natchez, Texas, Wayne, Republican line.
Yes, sir. I'm kind of confused because, I mean, this is very entertaining. I mean, I've watched it all the way through. It's very entertaining, but I didn't understand that the prosecution, okay, within the House, gets the defense, which is the president's team, to represent and to gather facts against their own client. Does that make sense to you? I mean, I don't know how legal this works, but I'm not being one of them daggum deplorables or something.
Okay, Wayne, Mesa, Arizona. We'll hear from Jim on the independent line next. Go ahead.
Yeah, thank you for taking my call. I just want anybody who's listening or watching this, if they go to trial, do they want the trial and convicted and then call witnesses? I think witnesses should be called. I think evidence should be presented. If the Republicans and the president have a defense, let them put it out there. Let them put witnesses out before they have a verdict. But go ahead and have his base say, oh, yeah, the Democrats are just a bunch of ponies and presenting poor evidence. Well, he did try to obstruct Congress, and he did hold money from Ukraine so he could get some benefit, so he could get Biden. And that's obvious. That's been proven. But why don't they let the other people come first, the witnesses? I don't understand that. If I go to trial, I want witnesses there for me or for the defense. I don't care who it is. I want witnesses to prove I'm innocent. I don't want the trial and no witnesses, and then they just determine, well, he's guilty because they didn't have anything. I think that's ridiculous. This is a joke. What the Republicans are doing is a joke.
And keep in mind, the way this day is structured is for debate on that resolution, the Senate Republican leader's resolution on how the trial will be conducted. He did make some changes to the resolution in that House managers and the president's attorneys will now have 24 hours over the course of 3 days. It had been 2. The resolution also changed to allow the evidence gathered presented by the House managers from the impeachment hearings and as part of the impeachment resolutions to be introduced automatically into the Senate. Any consideration in terms of witnesses and additional documents, according to the rules as they now stand, would be postponed until later. What Democrats have tried to do here in these first couple of amendments is try to get that included in the resolution. So far, they have failed on the first one. It was tabled 53-47. We go to Rotonda, West Florida, and hear from Greg on the Democrats line.
Hello. There's no choice but to impeach the crookedest president ever. It's our constitutional duty. I'm really getting tired of Republicans gaslighting the American people and denying the truth to us. It's traitorous to the United States. They're subverting our form of government, and they need to stand up and do what's right. I'm really tired of them saying we're trying to overturn an election because most people voted for Hillary Clinton, not Donald Trump. So that's ridiculous to say that. And there was plenty of evidence in the Mueller report of collusion, even if there wasn't sufficient evidence to charge for a chargeable offense. He found like over 100 instances of people in the Trump campaign meeting with Russians. It was overwhelming. And he found 10 instances of obstruction of justice. So this guy is guilty, and Republicans need to stop lying about it.
We'll go to Fultonville, New York next up. Pat, on the Republican line.
Thank you, sir. I appreciate you taking my call. I think, unfortunately, what the American public is witnessing is political theater. President Trump came in as a businessman, had no right or wrong as far as politics. He's doing what's right for the American people, and unfortunately, there's a lot out there with sour grapes. And if you just look at the numbers and what's happening, why can't Democrats and Republicans just get together and do what's right for the American people and continue with job creation and high stock market and American security? You can have hatred for someone. That's your own prerogative. But for a man who's lost almost $1 billion to be the president of the United States, he's got no reason to come out of the limelight and lose all that money if he didn't believe in what he's doing for us as Americans.
What's happened earlier this afternoon, John, not that long ago, the Senate tabled the First Amendment proposed by Senator Schumer to allow documents and witnesses relating to Ukraine aid. We expect another vote coming up on his second amendment, second proposal to the resolution dealing with State Department documents and evidence. A tweet here from Frank Thorpe of NBC, who covers the Hill, saying a statement from Senator Susan Collins, Republican of Maine, who had expressed an openness to witnesses in case there was any question, tweets Frank Thorpe. Senator Collins, in a statement, says, quote, "I will vote to table any attempts by either side to subpoena documents or witnesses before that stage in the trial." What she's referring to is under the resolution as it currently stands, that stage in the trial would come at the very end, after both sides have presented their cases, after senators had asked their questions through the Chief Justice. That would be the last phase of the trial. They would decide then on witnesses and further testimony. You are seeing the slate from the Senate, the video coming from the Senate. They're waiting for the chamber to gavel back in. That should be momentarily. They've been out now for about 20 minutes, what had been anticipated, but it often moves a little bit slower on the Senate side. So we will have them live when they gavel back in, of course. We'll hear from Jan next. Your thoughts, Independent Line. She's in Fort Benning, Georgia.
And you're listening to C-SPAN Radio as we are joining up with C-SPAN 2 Television to get your reaction to what you have seen and heard so far today.
Good afternoon. How are you doing today?
Fine. Go ahead, Jan.
Good. Well, first of all, I'm not a she. I'm a man. Unfortunately, I was named
my
that
bad.
back in. And it's no problem. I've had more opportunities to go to beautician school than most of the women here. I'm an independent. However, I used to be a Democrat. And with all this stuff that's been going on in the past several years, throughout several presidencies, the Democratic Party has lost my support. As far as this going on with President Trump, I agree with the man that just called from New York. He's a businessman. He's not a politician. He doesn't owe anybody anything. And most of the politicians that are in both the House and the Senate have been there way too long. I'm in agreement with a 4-year maximum term, no lifetime benefits for them. They're working for us, we, the people of the United States. President Trump came in there, and I thank him for what he's done. I'm a 32-year military career, retired sergeant major, living here on Fort Benning. I've seen waste and fraud from all the presidencies in government. They all have a reason to be where they're at. It's not for us. It's for their own personal gain. They have millions of dollars. They rub elbows. I've seen the contracts with the military because of such and such a person got them people. President Trump has come in there. He's not waiting for Congress or the Senate to sit there and argue for 5 and 6 months over something. He's a businessman.
All right, Jan, the president's legal team and the House managers presenting their cases, gathering their information, and submitting that over the weekend. Part of the submission by the Trump legal team said this: these articles reflect nothing more than the persecution of an intemperate or designing majority in the House of Representatives that the framers warned against. The Senate should reject the articles of impeachment and acquit the president immediately. waiting for the Senate to return. We expect they may take up a motion to table the latest second resolution, the second amendment proposed by Senator Schumer. We'll have live coverage when they're back. Sally is in Minneapolis, Minnesota. Democrats line.
Hello, thank you for taking my call.
Yep.
Well, first of all, I guess I don't feel sorry for President Trump. Look at what he did with Trump University and all the contractors that he stiffed. So no bad feelings, for him for that. And I have great respect for Adam Schiff. I think he's a tremendous leader, and he sees the truth in these issues. I think this is a very sad day to see the Republicans in the Senate defend the obstruction of truth from the American people. If the truth comes out at the end, hopefully it does. But if it doesn't, then I think that the American people have been stiffed. Thank you.
Sally's saying it's a sad day. Similar sentiment from Scott in St. Louis, texting 202-748-8003, saying it's pretty sad that they're rushing to get this thing done. Why is Mitch McConnell coordinating with the White House? How can there be separation of power if the executive gets to set the tone? To Oak Harbor, Ohio, we hear from Casey next up.
Hey, how are you? Thanks for having my call. I just wanted to say that as a Republican, the Republicans want nothing more than to see the evidence, see all the facts that the Democrats in the House have, but they have to have some sort of system to go about doing that. They didn't do that properly, and now they're in the Senate trying to get everything accomplished from the Senate, and that's not how the House is supposed to act. What's the point of having a House if they're not going to do their job? Thanks for.
Okay, Robin, Independent Line, Newport News, Virginia. Hi there.
Thank you for taking my call. Sad day in America, sad day for history. It is not about Republicans or Democrats. It's about the people in the United States and our democracy. And they are undermining the Constitution. And this is frankly why people stop going to the polls and voting, because we vote them in and then they get in office and they do what they want to do. They're not fighting for the people today. 50, whether it's Colin said in the beginning, I'm going to table it. No, you're supposed to come out with smoking guns in the beginning. It's not time to table. If he's innocent, then let the chips fall where they may. But President and his family, because he can't get any money from the United States anymore, filed bankruptcy 6 times or more, gets all of his money from Ukraine and the oligarchs in Russia. They got him by the balls, and his butthole is sewed up, and the Russians are turning his neck.
Well, to Ryan, next up, Cheyenne, Wyoming, on the Democrats line.
Hi there. This thing is just getting way too out of control. You got the Republicans in the Senate coordinating with the White House how to conduct the trial. That's like any convicted criminal going to the court system saying, oh, this is how I want it to go down. Do everything you can to prove my innocence. If he was as innocent as he claims, why doesn't he produce the documents and let the witnesses come testify on his behalf to clear his name instead of just saying that he's innocent? Anyone can say they're innocent. It takes someone who's truly innocent to be able to prove it.
Tell you where things are. We're about just about a half an hour into a break in the Senate. So far, they have blocked an amendment by Senator Schumer to allow documents and evidence related to the Ukraine aid. We will also likely see here coming up shortly when they're back, another effort to block or to table his second proposal, allowing documents and evidence from the State Department. Your thoughts and comments are welcome on text as well, 202-748-8003. This is from Rodney in Pennsylvania, who says the socialists can't accept losing the election. They've made several failed attempts to overturn the will of the American people. Pathetic. My name is Kenny from Bismarck, North Dakota. I believe from the beginning this whole thing was a sham, and the Democrats are going to get what they deserve come election time. New York, California, any other Democratic state should vote. Read this. Is very appalling what they are doing to the President of the United States. And from Robert in Arizona, I keep hearing, quote, nobody is above the law, yet I seem to be missing hearing innocent until proven guilty. It is not the juror's job to prove to add to the case. It is their job to weigh the facts presented. If the case was not ready, it should not have been sent forward. If it is, there should be no need for additional gathering information or witnesses.
And back live to the Senate floor, Chief Justice John Roberts presiding.
The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent?
Proponent, Mr. Chief Justice.
Thank you. And Mr. Cipollone?
Opponent.
Okay. Mr. Schiff, you have an hour and will be able to reserve time for rebuttal.
The Chief Justice was addressing Congressman Adam Schiff, the lead impeachment manager. Coming up to argue on behalf of the House managers is another manager, Congresswoman Val Demings, Democrat from Florida.
Chief Justice Roberts, Senators, Counsel for the White House. I am Val Demings from the state of Florida. The House managers strongly support the amendment to issue subpoena for documents to the State Department. As we explain, the first article of impeachment charges the president with using the power of his office to solicit and pressure Ukraine to announce investigations that everyone in this chamber knows to be bogus. The president didn't even care if an investigation was actually conducted, just that it was announced. Why? Because this was for his own personal and political benefit. The first article further charges that the president did so with corrupt motives and that his use of power for personal gain harmed the national security of the United States. As the second article of impeachment charges, the president sought to conceal evidence of this conduct. He did so by ordering his entire administration, every office, every agency, every official to defy every subpoena served in the House impeachment inquiry. No president in history has ever done anything like this. Many presidents have expressly acknowledged that they couldn't do anything like this. President Trump did not take these extreme steps to hide evidence of his innocence or to protect the institution of the presidency. As a career law enforcement officer, I have never seen anyone take such extreme steps to hide evidence allegedly proving his innocence. And I do not find that here today. The president is engaged in this cover-up because he is guilty, and he knows it. And he knows that the evidence he is concealing will only further demonstrate his culpability. Notwithstanding this effort to stonewall our inquiry, the House amassed powerful evidence of the president's high crimes and misdemeanors. 17 witnesses, 130 hours of testimony combined with the president's own admissions on phone calls and in public comments, confirmed and corroborated by hundreds of texts, emails, and documents. Much of that evidence came from patriotic, nonpartisan, decorated officials in the State Department. They are brave men and women who honored their obligations under the law and gave testimony required by congressional subpoena in the face of the president's taunts and insults. These officials described the president's campaign to induce and pressure Ukraine to announce political investigations, his use of $391 million of vital military aid, taxpayer money appropriated on a bipartisan basis by Congress as leverage to force Ukraine to comply, and his withholding of a meeting desperately sought by the newly elected president of Ukraine. This testimony was particularly compelling because the State Department is at the very center of President Trump's wrongdoing. We heard firsthand from diplomatic officials who saw up close and personal what was happening and who immediately sounded the alarms. Ambassador William Taylor, who returned to Ukraine in June of last year as acting ambassador, texted other State Department officials. I think it's crazy to withhold security assistance for help with a political campaign. Ambassador to the European Union, Gordon Sondland, who was delegated authority over Ukraine matters by none other than President Trump, testified, "We knew these investigations were important to the president, and we followed the president's orders." And David Holmes, a senior official at the U.S. Embassy in Kyiv, said it was made clear that some action on a Burisma Biden investigation was a condition for an Oval Office meeting. During their testimony, many of these State Department officials described specific documents, including text messages, emails, former diplomatic cables, and notes that would corroborate their testimony and shed additional light on President Trump's corrupt scheme. For instance, Ambassador Taylor, who raised concerns that military aid had been conditioned on the president's demand for political investigations, described a little notebook in which he would take notes on conversations he had with key officials. Ambassador Sondland referred by date and recipient to emails regarding the president's demand that Ukraine announce political investigations. As we'll see through emails that were sent to some of President Trump's top advisors, including acting White House Chief of Staff Mick Mulvaney, Secretary of State Michael Pompeo, and Secretary of Energy Rick Perry. Deputy Assistant Secretary of State George Kent, who oversaw Ukraine policy matters in Washington for the State Department, wrote at least 4 memos to file to document concerning conduct he witnessed or heard. And Ambassador Kurt Volker, the special representative for Ukraine negotiations, provided evidence that he and other American officials communicated with high-level Ukrainian officials, including President Zelensky himself, via text message and WhatsApp, about the president's improper demands and how Ukrainian officials would respond to them. Based on the testimony we received and on evidence that has since emerged, all of these documents and others that we will describe bear directly on the allegations set forth in the first article of impeachment.
House Impeachment Manager Congresswoman Val Demings.
Complete our understanding of how the president's scheme unfolded in real time. They would support the conclusion that senior Ukrainian officials understood the corrupt nature of President Trump's demand, and they would further expose the extent to which Secretary Pompeo, Acting Chief of Staff Mick Mulvaney, and other senior Trump administration officials were aware of the president's plot and helped carry it out. We're not talking about a burdensome number of documents. We're talking about a specific, discrete set of materials held by the State Department. Documents the State Department has already collected in response to our subpoena, but has never produced. We know these materials exist. We know they are relevant, and we know the president is desperately trying to conceal them. As I will describe, the Senate should subpoena the following. Number one, WhatsApp and other text message communications. 2, emails. 3, diplomatic cables. And 4, notes. Given the significance and relevance of these documents, the House requested that they be provided. When these requests were denied, when our requests were denied, the House issued subpoenas commanding that the documents be turned over. But at the president's direction, the Department of State unlawfully defied that subpoena. And I stand here now. As I stand here now, the State Department has all these documents in its possession, but refuses, based on the president's order, to let them see the light of day. This is an affront to the House, which has full power to see these documents. It is an affront to the Senate, which has been denied a full record on which to judge the president's guilt or innocence, and it is an affront to the Constitution, which makes clearly that nobody, not even the president, is above the law. And it is an affront to the American people, who have a right to know what the president and his allies are hiding from them and why it is being hidden. In prior impeachment trials, this body has issued subpoenas requiring the recipient to hand over relevant documents. It must do so again here. And it must do so now at the beginning of the trial, not the end. Of course, the need for a Senate subpoena arises because, as I've noted, the president ordered the State Department to defy a subpoena from the House. At this point, I'd like to briefly describe our own efforts to get those materials. I'll then address in a more detailed fashion exactly what documents the State Department has hidden from the American people and why the Senate should require it to turn them over. On September 9th, exercising their Article I oversight authority, the House Investigating Committee sent a document request to the State Department. The committee sought materials related to the president's effort to pressure Ukraine to announce investigations into his political rival, as well as his dangerous, unexplained withholding of millions of dollars in vital military aid. After the State Department failed to produce any documents, the House Committee on Foreign Affairs issued a subpoena to the State Department on September 27th. In a letter on October 1st, Secretary Pompeo acknowledged receipt of the subpoena. At that time, he stated that he would respond to the committee's subpoena for documents by the return date, October 4th. But his response never came. Instead, on October 8th, President Trump's lawyer, writing on the president's behalf, issued a direction confirming that the administration would stonewall the impeachment inquiry. To date, the State Department has not produced a single document, not a single document in response to the congressional subpoena. But witnesses who testified indicated that the State Department had gathered all of the records and was prepared to provide them before the White House directed it to defy the subpoena. Notwithstanding this unlawful obstruction through the testimony of brave State Department employees, the House was able to identify with remarkable precision several categories of documents relevant to the first article of impeachment that are sitting right now. Right now. Those documents are sitting right now at the State Department.
House Impeachment Manager Congresswoman Val Demings.
Walk you through 4 key categories of documents that should be subpoenaed and which illustrate the highly relevant documents the State Department could produce immediately They could produce them immediately for this trial. The first category consists of WhatsApps and other text messages from State Department officials caught up in these events, including Ambassadors Sondland and Taylor, and also Deputy Assistant Secretary George Kent, all three of whom confirm in their testimony that they regularly use WhatsApp to communicate with each other and foreign government officials. As Deputy Assistant Secretary Kent explained, WhatsApp is a dominant form of electronic communication in certain parts of the world. We know that the State Department possesses the records of WhatsApp and text messages from critical eyewitnesses to these proceedings, including from Ambassador Sondland and Taylor and Deputy Assistant Secretary Kent. We know that the department is deliberately concealing these records at the direction of the president, and we know that they could contain highly relevant testimony about the president's plan to condition official presidential acts on the announcements of investigations for his own personal and political gain. We know this not only from testimony, but also because Ambassador Volker was able to provide us with a small but telling selection of his WhatsApp messages. Those records confirm with a full review of these texts and WhatsApp messages from relevant officials would help to paint a vivid, first-hand picture of statements, decisions, concerns, and beliefs held by important players of events unfolding in real time. For example, thanks to Ambassador Volker's messages, we know that Ambassador Sondland, a key player in the president's pressure campaign, who testified in the House about a quid pro quo arrangement, texted directly with the Ukrainian President Zelensky. This image, produced by Ambassador Volker, appears to be a screenshot of a text message that Ambassador Sondland exchanged with President Zelensky about plans for the White House visit, the very same visit that President Zelensky badly needed, and that President Trump later withheld as part of the quid pro quo described by Ambassador Sondland in his testimony. This body and the American people have a right to know what else Ambassador Sondland and President Zelensky said in this and other relevant exchanges about the White House meeting or about the military aid and the president's demand. But we don't know exactly what was conveyed and when. We don't know if President Trump directed the State Department to conceal these vital records. These are records that the State Department would have otherwise turned over if not for the president's direction and desire to cover up his wrongdoing. To get a sense of why texts and WhatsApp messages are so vital, just consider whether another piece of evidence we've gleaned from Ambassador Volker's partial production. On July 10th, at the White House meetings at which Ambassador Sondland pressured Ukrainian officials to announce investigations of President Trump's political opponents, a Ukrainian governmental official texted Ambassador Volker, "I feel that the key for many things is Rudy, and I am ready to talk with him at any time." This is evidence that immediately following Ambassador Sondland's ultimatum, Ukrainian officials recognized that they needed to appease Rudy Giuliani by carrying out the investigations. Of course, Mr. Giuliani had publicly confirmed that he was not engaged in foreign policy, but it was instead advancing his clients, the president's own personal interest. Further, in another text message exchange provided by Ambassador Volker, we see evidence that Ukraine understood President Trump's demands loud and clear. On the morning of July 25th, half an hour before the infamous call between President Trump and President Zelensky, Ambassador Volker wrote to a senior Ukrainian official heard from White House. Assuming President Z convinces Trump he will investigate, get to the bottom of what happened in 2016, we will nail down date for visit to Washington. Good luck. See you tomorrow. Kurt. Ambassador Sondland confirmed that this text accurately summarized the president's directive to him earlier that morning. After the phone call between President Trump and President Zelensky, the Ukrainian official responded pointedly. Phone call went well. He then discussed potential dates for a White House meeting. Then the very next day, Ambassador Volker wrote to Rudy Giuliani exactly the right messages as we discussed. These messages confirm Mr. Giuliani's central role, the premeditated nature of President Trump's solicitation of political investigation and the pressure campaign on Ukraine waged by Mr. Giuliani and senior officials at President Trump's direction.
House Impeachment Manager Val Demings, Democratic Congresswoman, on the Senate floor on C-SPAN Radio.
And this is just some of what we learned from Ambassador Volker's records. As you will see during this trial presentation, there were numerous WhatsApp messages in August while Ambassadors Volker and Sondland and Mr. Giuliani were pressuring President Zelensky's top aide to issue a statement announcing the investigations that President Trump wanted. And Ambassador Taylor's text that you saw earlier about withholding the aid further reveals how much more material there likely is that relates to the articles of impeachment. There can be no doubt that a full production of relevant text and WhatsApp messages from other officials involved in Ukraine and in touch with Ukrainian officials, including Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, would further illuminate the malfeasance addressed in our first article. This leads to the second category of documents that the State Department is unlawfully withholding: emails involving key State Department officials concerning interactions with senior Ukrainian officials and relating to military aid, a White House meeting, and the president's demand for investigations into his rivals. For example, on July 19th, Ambassador Gordon Sondland spoke directly with President Zelensky about the upcoming July 25th call between President Trump and President Zelensky. Ambassador Sondland then sent an email updating key officials about Secretary Pompeo, including Secretary Pompeo, Acting White House Chief of Staff Mulvaney, and his senior advisor, Robert Blair. In this email, he noted that he prepared President Zelensky, who was willing to make the announcements of political investigations that President Trump desired. Secretary Perry and Mick Mulvaney then responded to Sondland, acknowledging they received the email and recommending to move forward with the phone call. That became the July 25 call between the presidents of the United States and Ukraine. We know all of this not because the State Department provided us with critical document, but instead because Ambassador Sondland provided us a reproduction of the email. In his public testimony, Ambassador Sondland quite correctly explained that this email demonstrated, quote, everyone was in the loop.
Everyone was in the loop. It was no secret. Everyone was informed via email on July 19th, days before the presidential call. As I communicated to the team, I told President Zelensky in advance that assurances to run a fully transparent investigation and turn over every stone were necessary in his call with President Trump. Even viewed alone, this reproduced email is damning.
It was sent shortly after Ambassador Sondland personally conveyed the president's demand for investigations to Ukrainians at the White House, leading several officials to sound alarms. It was sent just a few days before the July 25 call, where President Trump asked for a favor. And by itself, this email shows who was embroiled in President Trump's plan to pressure the Ukrainian president for his own political gain. But it's obvious that the full email chain and other related emails to this key time period would also be highly relevant. We don't have those emails because the State Department is hiding them at the direction of the president. The Senate should issue the proposed subpoena to ensure a complete record of these and other relevant emails. Any doubt that the State Department is concealing critical evidence from this body was resolved when the State Department was recently ordered to release documents, including emails pursuant to a lawsuit under the Freedom of Information Act. These documents are heavily redacted and are limited to a very narrow time period. But nevertheless, despite the heavy redactions, these highly limited glimpse into the State Department's secret record demonstrates that those records are full of information relevant to this trial. For example, several of these newly elected or released emails show multiple contacts between the State Department, including Secretary Pompeo and Mr. Giuliani throughout 2019. This is an important fact. Mr. Giuliani served as the president's point person in executing his corrupt scheme. Mr. Giuliani repeatedly emphasized that his role was to advance the president's personal agenda. The president's political interests, not to promote the national security interest of the United States. The fact that the president's private attorney was in contact at key junctures with the Secretary of State, whose senior officials were directed by the president to support Mr. Giuliani's efforts in Ukraine, is relevant, disturbing, and telling. For example, we know that on March 26th, as Mr. Giuliani was pursuing the president's private agenda in Ukraine, and just 1 week after the Hill published an article featuring Mr. Giuliani's Ukraine conspiracy theories, Secretary Pompeo and Mr. Giuliani spoke directly on the phone. That same week, President Trump's former personal secretary was asked by Mr. Giuliani's assistant for a direct connection to Secretary Pompeo. Based on these records, it is also clear that Secretary Pompeo was already actively engaged with Mr. Giuliani in early spring of 2019. And it also appears that these efforts were backed by the White House, given the involvement of President Trump's personal secretary.
Congresswoman Val Demings, House impeachment manager, debating Senator Schumer's resolution to subpoena the State Department documents.
This body and the American people need to see these emails and other files at the State Department, fleshing out these exchanges and the details surrounding Mr. Giuliani's communications with Secretary Pompeo. Moreover, based on call records lawfully obtained by the House from this period, we know that from March 24th to March 30th, Mr. Giuliani called the White House several times and also connected with an unidentified number numerous times. These records show that on March 27th, Mr. Giuliani placed a series of calls to the State Department switchboard, Secretary Pompeo's assistant, and the White House switchboard in quick succession, all within less than 30 minutes. Obtaining emails and other documents regarding the State Department's leadership's interaction with President Trump's private lawyer in this period, when Mr. Giuliani was actively orchestrating the pressure campaign in Ukraine related to the sham investigation into Vice President Biden and the 2016 election, would further clarify the president's involvement and direction at this key juncture in the formation of a plot to solicit foreign interference into our election. We also know, based on recently obtained documents, that Les Parmas, an associate of Rudy Giuliani, has assisted him in his representation of President Trump, that Giuliani likely spoke with Secretary Pompeo about Ukraine matters even earlier than previously understood. According to documents obtained from Mr. Parmas, Mr. Giuliani wrote in early February of 2019 that he apparently spoke with Secretary Pompeo about the removal of the U.S. ambassador in Ukraine, Marie Yovanovitch. Mr. Giuliani viewed her as an impediment to implementing the president's corrupt scheme and orchestrated a long-running smear campaign against her. Here's what Mr. Parmas said about this just last week.
Do you believe that part of the motivation to get rid of Ambassador Yovanovitch, to get her out of post, was because she was in the way of this effort to get the government of Ukraine to announce investigations of Joe Biden?
That was the only motivation.
That was the only motivation.
There's no other motivation.
These are just some of the email communications that we know. These are just some of the email communications that we know to exist, but there are undoubtedly more, including, for example, Ambassador Yovanovitch's request for the State Department to issue a statement of support of her around the time that Mr. Giuliani was speaking directly with Secretary Pompeo. But that statement never came. The State Department has gathered these records and they are ready to be turned over, pursuant to a subpoena from the Senate. It would not be a time-consuming or lengthy process to obtain them, and there are clearly important and relevant documents to the president's scheme. If we want the full and complete truth, then we need to see those emails. The Senate should also seek a third item that the State Department has refused to provide, and that's Ambassador Taylor's extraordinary first-person diplomatic cable to Secretary Pompeo dated August 29 and sent at the recommendation of the National Security Advisor John Bolton, in which Ambassador Taylor strenuously objected to the withholding of military aid from Ukraine, as Ambassador Taylor recounted in his deposition.
Near the end of Ambassador Bolton's visit, I asked to meet him privately, during which I expressed to him my serious concern about the withholding of military assistance to Ukraine while the Ukrainians were defending their country from Russian aggression. Ambassador Bolton recommended that I send a first-person cable to Secretary Pompeo directly, relaying my concerns. I wrote and transmitted such a cable on August 29th, describing the folly I saw in withholding military aid to Ukraine at a time when hostilities were still active in the East and when Russia was watching closely to gauge the level of American support for the Ukrainian government. The Russians, as I said at my deposition, would love to see the humiliation of President Zelensky at the hands of the Americans. I told the Secretary that I could not and would not defend such a policy. Although I received no specific response, I heard that soon thereafter, the Secretary carried the cable with him to a meeting at the White House focused on security assistance for Ukraine.
While we know from Ambassador Taylor and Deputy Assistant Secretary Kent that the cable was received, we do not know whether or how the State Department responded, nor do we know if the State Department possesses any other internal records relating to this cable. This cable is vital for 3 reasons. First, it demonstrates the harm that President Trump did to our national security when he used foreign policy as an instrument of his own personal political gain. Second, on the same day the cable was sent, President Zelensky's senior aide told Ambassador Taylor that he was very concerned about the hold on military assistance. He added that the Ukrainians were just desperate at it to be released. In other words, President Trump's effort to use military aid to apply additional pressure on Ukraine was working. And finally, based on reporting by the New York Times, we now know that within days of Ambassador Taylor sending this cable, President Trump discussed Ukrainian security assistance with Secretary Pompeo, Defense Secretary Esper, and National Security Advisor Bolton. The investigation uncovered testimony that Secretary Pompeo brought Ambassador Taylor's cable to the White House. Perhaps it was during this meeting. There, perhaps prodded by Ambassador Taylor's cable, all 3 of them pleaded with the president to resume the crucial military aid. Yet the president refused.
Congresswoman Val Demings, House Impeachment Manager on the Senate floor.
This body has a right to see Ambassador Taylor's cable as well as the other State Department records addressing the official response to it. Although it may have been classified at the time, the State Department can no longer claim that the topic of security assistance remains classified today in light of the president's decision to declassify his 2 telephone calls with President Zelensky and Mr. Mulvaney's public statements about security assistance. The 4th category of documents that the Senate should subpoena are contemporaneous first-person accounts from State Department officials who were caught up in President Trump's corrupt scheme. These documents, which were described in detail by Deputy Assistant Secretary Kent, Ambassador Taylor, and political officer David Holmes, would help complete the record and clarify how the president's scheme unfolded in real time and how the Ukrainians reacted. Mr. Kent wrote notes or memos to file at least 4 times, according to his testimony. Ambassador Taylor took extensive notes of nearly every conversation he had, some in a little notebook. And David Holmes, the embassy official in Ukraine, was a consistent note taker of important meetings with Ukrainian officials.
Did you take notes of this conversation on September 1st with Ambassador Sondland?
I did.
And did you take notes related to most of the conversations, if not all of them, that you recited in your opening statement?
All of them, Mr. Goldman.
And you are aware, I presume, that the State Department has not provided those notes to the committee. Is that right?
I am aware.
So we don't have the benefit of reviewing them to ask you these questions.
Correct. I understand that they may be coming sooner or later.
Well, we would welcome that.
The State Department never produced those notes. As another example, Deputy Assistant Secretary Kent testified about a key document that he drafted on August 16th, describing his concerns that the Trump administration was attempting to pressure Ukraine into opening politically motivated investigations.
I'd like to start with you, Mr. Kent. In your testimony, you said that you had, in mid-August, it became clear to me that Giuliani's efforts to gin up politically motivated investigations were now infecting U.S. engagement with Ukraine, leveraging President Zelensky's desire for a White House meeting. Mr. Kent, did you actually write a memo documenting your concerns that there was an effort underway to pressure Ukraine to open an investigation to benefit President Trump?
Yes, ma'am. I wrote a memo to the file on August 16th.
But we don't have access to that memo, do we?
I submitted it to the State Department subject to the September 27th subpoena.
And we have not received one piece of paper from the State Department relative to this investigation.
Deputy Assistant Secretary Kent also memorialized a September 15 conversation at which Ambassador Taylor described a Ukrainian official accusing America of hypocrisy for advising President Zelensky against investigating a prior Ukrainian president. Mr. Kent described that conversation during his testimony. He said, but the more awkward part of the conversation came after Special Representative Volker made the point that the Ukrainians, who had opened their authorities under President Zelensky, had opened investigations of former President Poroshenko. He didn't think that was appropriate. And then Andrei Yermak said, what? You mean the type of investigations you're pushing for us to do on Biden and Clinton? The conversation makes clear the Ukrainian officials understood the corrupt nature of President Trump's requests and therefore doubted American credibility on anti-corruption measures. Records of these conversations and other notes and memoranda by senior American officials in Ukraine would flesh out and help complete the record for the first article of impeachment. They would tell the whole truth and to the American people and to this body. You should require the State Department to provide them. To summarize, the Senate should issue the subpoena proposed in the amendment requiring the State Department to turn over relevant texts and WhatsApp messages, emails, diplomatic cables, and notes. These documents bear directly on the trial of this body, the trial that this body is required by the Constitution to hold. They are immediately relevant to the first article of impeachment. Their existence has been attested to by credible witnesses in the House. And the only reason we don't already have them is that the President has ordered his administration, including Secretary Pompeo, to hide them. The President's lawyers may suggest that the House should have sought these materials in court or awaited further lawsuits under the Freedom of Information Act, aka FOIA lawsuits. Any such suggestion is meritless. To start, the Constitution has never been understood to require such lawsuits, which has never occurred in any previous impeachment. Moreover, the President has repeatedly and strenuously argued that the House is not even allowed to file a suit to enforce its subpoenas. And in the Freedom of Information Act cases, the administration has only grudgingly and slowly produced an extremely small set of materials, but has insisted on applying heavy and dubious redactions. FOIA lawsuits filed by third parties cannot serve as a credible alternative to congressional oversight. In fact, it is still alarming that the administration has produced more documents pursuant to the Federal Office of Information Act lawsuits by private citizens and entities than congressional subpoenas.
House Impeachment Manager Congresswoman Val Demings. Live, WCSP-FM, Washington.
As we all know, litigation would take an extremely long time, likely years, not weeks or months, while the misconduct of this president requires immediate attention. The misconduct of this president requires immediate attention. If this body is truly committed to a fair trial, it cannot let the president play a game of keep away and dictate what evidence the senators can and cannot see bearing on his guilt or innocence. This body cannot permit him to hide all the evidence while disingenuously insisting on lawsuits that he doesn't actually think we can file, ones that he knows won't be resolved until after the election. He is trying to cheat to win. Instead, to honor your oaths to do impartial justice, we urge each senator to support a subpoena to the State Department. And that subpoena should be issued now, at the beginning of the trial, rather than at the end, so these documents can be reviewed and their importance weighed by the parties, the Senate, and by the American people. That is how things work in every courtroom in the nation. And it is how they should work here, especially because the stakes, as you all know, are so high. The truth is there. Facts are stubborn things. The president is trying to hide it. This body should not surrender to his obstruction by refusing to demand a full record. That is why the House managers support this amendment. And Mr. Chief Justice, the House managers reserve the balance of our time.
Congresswoman Val Demings, House Impeachment Manager. The amendment offered by the Senate Democratic leader Chuck Schumer to the underlying impeachment trial organizing resolution offered by the Majority Leader Mitch McConnell.
Mr. Cipollone.
Pat Cipollone is White House counsel.
Thank you, Mr. Chief Justice. In the interest of time, I won't repeat all of the arguments that we've made already with respect to these motions. I would say one thing before I turn it over to my co-counsel. Mr. Schiff came here and said he's not asking you to do something he wouldn't do for himself. And the House manager said, we're not asking you to do our jobs for us. And Mr. Schiff came up here and he said, I call Ambassador Bolton. Remember Paul Harvey? It's time for the rest of the story. He didn't call him in the House. He didn't subpoena Ambassador Bolton in the House. I have a letter here from Ambassador Bolton's lawyer. He's the same lawyer that Charlie Kupperman hired. Stated November 8th. He said, I write as counsel to Dr. Charles Kupperman and to Ambassador John Bolton. In response to to the letter of November 5th from Chairman Schiff, Chairman Engel, and Acting Chair Maloney, the House chairs, withdrawing the subpoena to Dr. Kupperman. I mentioned that earlier. And to recent published reports announcing that the House chairs do not intend to issue a subpoena to Ambassador Bolton. He goes on and says, we are dismayed that the committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question. And he ends the letter by saying, if the House chooses not to pursue through subpoena the testimony of Dr. Kupperman and Ambassador Bolton, let the record be clear. That is the House's decision. And they made that decision. They never subpoenaed Ambassador Bolton. They didn't try to call him in the House. And they withdrew the subpoena for Charles Kupperman before the judge could rule, and they asked that the case be mooted. And now they come here and they ask you to issue a subpoena for John Bolton. It's not right. I yield the remainder of my time to Mr. Sekulow.
Jay Sekulow is President Donald Trump's personal attorney.
Members of the Senate, the manager said facts are a stubborn thing. Let me give you some facts. It's from the transcripts. Ambassador Sondland actually testified unequivocally that the president did not tie aid to investigations. Instead, that he acknowledged any leak he had suggested was based entirely on his own speculation, unconnected to any conversation with the president. Here's the question. What about the aid? Ambassador Volker says that they were tied, that the aid was not tied. Answer. I didn't say that they were conclusively tied either. I said I was presuming it. Question. Okay. And so the president never told you they were tied. Answer. That is correct. Question. So your testimony and Ambassador Volker's testimony is consistent. And the president did not tie investigations, aid to investigations. Answer. That is correct. Ambassador Sondland also testified that he asked President Trump directly about these issues, and the president explicitly told him that he did not want anything from Ukraine. I want nothing. I want nothing. I want no quid pro quo. Tell Zelensky to do the right thing. Similar comments were made to Senator Johnson. Those are the facts. Stubborn, but that's the facts. No one is above the law. Here's the law. As every member of Congress knows, undoubtedly aware, separate from even state secret privileges is the presidential communication executive privilege to communications and performance of a president's responsibilities. The presidential communication privilege has constitutional origins. Courts have recognized a great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties, because such confidentiality is needed to protect the effectiveness of the executive decision-making process. In Ray Seal cases, that was decided in the District of Columbia Court of Appeals. The Supreme Court found such a privilege necessary to guarantee the candor of presidential advisors and to provide a president and those who assist him with freedom to explore alternatives in the process of ultimately shaping policies and making decisions, and to do so in a way many would be unwilling to express except in private. For these reasons, presidential conversations are presumptively privileged. There's something else about this privilege. Communications made by presidential advisors, again, quoting courts. And by the way, lawyer lawsuits, we're talking about the impeachment of a president of the United States, duly elected. And the managers are complaining about lawyer lawsuits? The Constitution allows lawyer lawsuits. It's disrespecting the Constitution of the United States to even say that in this chamber. Lawyer lawsuits. Here's the law. Communications made by presidential advisors in the course of preparing advice for the president come under the presidential communications privilege, even when these communications are not made directly to the president. Even when they're not made directly to the president, advisor to advisor. Given the need to provide sufficient elbow room for advisors to obtain information from all knowledgeable sources, the privilege must apply both to communications which these advisors solicit and receive from others, as well as those they authorize themselves. The privilege must also extend to communications authored or received in response to solicitation by members of a presidential advisor's staff, since in many instances, advisors must rely on their staffs to investigate an issue and formulate advice given to the president. Lawsuits. The Constitution. A dangerous moment for America when an impeachment of a president of the United States is being rushed through because of lawyer lawsuits. The Constitution allows it if necessary. The Constitution demands it, if necessary. Thank you, Mr. Chief Justice.
Jay Sekulow is President Donald Trump's personal attorney from the U.S. Senate floor. Chief Justice John Roberts presiding. Consideration of an amendment to the organizing resolution for the impeachment trial.
Mr. Stemmings, you have 13 minutes for rebuttal. Mr. Schiff.
And coming to speak is House Impeachment Manager, Congressman Adam Schiff.
Thank you, Mr. Chief Justice. Let me just respond to some of my colleagues' points, if I can. First, counsel said, well, the House would like to call John Bolton, but the House did not seek his testimony during its investigation. Well, first of all, we did. We invited John Bolton to testify, and you know what he told us? I'm not coming, and if you subpoena me, I will sue you. That was his answer. I will sue you. Mr. Bolton is represented by the same lawyer who represents Dr. Kupperman, who actually did sue us when he was subpoenaed. So we knew that John Bolton would make good on that threat. Now, Mr. Sekulow says something about lawyer lawsuits. Now, I have to confess I wasn't completely following the argument, but something about lawyer lawsuits, that we're against lawyer lawsuits. Well, I don't know what that means, but I can tell you this. The Trump Justice Department is in court in that case and other cases arguing Congress cannot go to court to enforce its subpoenas. So when they say something about lawyer lawsuits and they say there's nothing wrong with the House suing to get these witnesses to show up, and they should have sued to get them to show up, their own other lawyers are in court saying the House has no such right. They're in court saying you can't have lawyer lawsuits. So that argument cannot be made in both directions. What's more, in the Kupperman litigation, in the McGahn litigation, which tested this same bogus theory of absolute immunity, in that lawsuit, once again involving the president's lawyer, Don McGahn, the one who was told to fire the special counsel and then to lie about it, that lawsuit, to get his testimony. Judge Jackson ruled on that very recently when they made the same bogus claim, he's absolutely immune from showing up. And the judge says that's nonsense. There's no support for that, none in the Constitution, none in the case law. That is made out of whole cloth. But you know, the judge said something more that was very interesting. Because what we urged John Bolton's lawyer is, you don't need to file a lawsuit. Dr. Kupperman, you don't need to file a lawsuit. There's one already filed involving Don McGahn that's about to be decided. So unless your real purpose here is delay, unless your real purpose here is to avoid testimony and you just wish to give the impression of a willingness to come forward, you just want to have the court's blessing, if that's really true, agree to be bound by the McGahn decision. Well, of course they were not willing, because they didn't want to testify. Now, for whatever reason, John Bolton is now willing to testify. I don't know why that is. Maybe it's because he has a book coming out. Maybe it's because it will be very hard to explain why he was unwilling to share important information with the Senate, that he couldn't show up for a House deposition or interview because he would need court permission to do it, but he can put it in a book. I don't know. I can't speak to his motivation. But I can tell you he's willing to come now, if you're willing to hear him. But of course, they weren't willing to be bound by that court decision in McGahn. But the court said something very interesting. Because one of the arguments they had been making, one of the arguments that John Bolton's lawyer had been making, as to why they needed their own separate litigation was, well, John Bolton and Dr. Kupperman, they're national security people, and Don McGahn is just the White House counsel. No offense to the White House counsel, but apparently you have nothing to do with national security. And so they couldn't be bound by what the court in the McGahn case said. Well, the judge in the McGahn case said, this applies to national security stuff too. So we do have a court decision, and what's more, we have the court decision in the Harriet Miers case in the George W. Bush administration, where likewise the court made short shrift of this claim of absolute, complete, and total immunity. Now, there were also comments made about Ambassador Volker's testimony by Mr. Sekulow. And it was along these lines. Ambassador Volker said the president never told him that the aid was being conditioned or the meeting was being conditioned on Ukraine doing these sham investigations. Well, I guess that's case closed. Unless the president told everyone, called them into their office and said, hey, I'm going to tell you now, and then I'm going to tell you now. If he didn't tell everyone, I guess it's case closed. Well, you know who the president did tell, among others? He told Mick Mulvaney. Mick Mulvaney went out on national television and said, yes, they discussed it. This investigation, this Russian narrative that it wasn't Ukraine that intervened in 2016, it was Russia. I'm sorry, it wasn't Russia, it was Ukraine. Yes, that bogus 2016 theory, yes, they discussed it. Yes, that was part of the reason why they withheld the money. And when reporters said, well, you're kind of describing a quid pro quo, his answer was, yeah, get used to it or get over it. We do it all the time. Now, they haven't said they want to hear from Mick Mulvaney. I wonder why. The president did talk to Mick Mulvaney about it. Wouldn't you like to hear what Mick Mulvaney has to say? I mean, if you really want to get to the bottom of this, if they're really challenging the fact that the president conditioned $400 million of military aid to an ally at war, if Mick Mulvaney has already said publicly that he talked to the president about it, and this is part of the reason why, don't you think you should hear from him? Don't you think impartial justice requires you to hear from him? Now, counsel also referred to Ambassador Sondland, and Sondland saying, well, the president told me there was no quid pro quo. Now, of course, at the time the president said to Sondland, no quid pro quo, he became aware of the whistleblower complaint, presumably by Mr. Cipollone. And so the president knew that this was going to come to light. On the advice, apparently, of Mr. Cipollone, or maybe others, the Director of National Intelligence, for the first time in history, withheld a whistleblower complaint from Congress, its intended recipient. But nonetheless, the White House was aware of that complaint. We launched our own investigations. Yes, they got caught, and in the midst of being caught, what does he say? It's called a false exculpatory. For those people at home, that's a fancy word of saying it's a false, phony alibi. No quid pro quo. He wasn't even asked the question, was there a quid pro quo? He just blurted it out. That's the defense, that the president denies it. And what's more interestingly, he didn't tell you about the other half of that conversation where the president says no quid pro quo. He says no quid pro quo. But Zelensky needs to go to the mic. And he should want to do it. Which is the equivalent of saying no quid pro quo except the quid pro quo. And here's what the quid pro quo is. He needs to go to the mic and he should want to do it.
House Impeachment Manager Congressman Adam Schiff.
Their alibi? They didn't also mention, of course, and you'll hear about this during the trial if we have a real trial. Ambassador Sondland also said that we're often asked, was there a quid pro quo? The answer is yes, there was a quid pro quo. There was an absolute quid pro quo. And what's more, when it came to the military aid, it was as simple as 2 + 2. Well, I'll tell you something. We're not the only people who can add up 2 + 2. There are millions of people watching this can add up 2 + 2 also. When the president tells his chief of staff we're holding up the aid because of this, as the chief of staff admitted, when the president gives no plausible or other explanation for holding up aid that you all and we all supported and voted on a very bipartisan way, has no explanation for it, when in that call he never brings up corruption except the corruption he wants to bring about, it doesn't take a genius, it doesn't take Albert Einstein to add 2 + 2. It equals 4. In this case, it equals guilt. Now, you're going to have 16 hours to ask questions. You're going to have 16 hours. That's a long time to ask questions. Wouldn't you like to be able to ask about the documents in that 16 hours? Would you like to be able to say, counsel for the president, what did Mick Mulvaney mean when he emailed so-and-so and said such and such? What's your explanation for that? Because that seems to be pretty damning evidence of exactly what the House is saying here. What's your explanation of that, Mr. Sekulow? What's your explanation? Wouldn't you like to be able to ask about the documents? Or ask the House, Mr. Schiff, What about this text message? Doesn't that suggest such is what the president is arguing? Wouldn't you like to be able to ask me that question or my colleagues? I think you would. I think you should. But the backwards way this resolution is drafted, you get 16 hours to ask questions about documents you've never seen. And then you know what's more? If you do decide at that point after the trial is essentially over that you do want to see the documents after all, and the documents are produced, you don't get another 16 hours. You don't get 16 minutes. You don't get 16 seconds to ask about those documents. Does that make any sense to you? Does that make any sense at all? I'll tell you something I'd like to know that may be in the documents. You probably heard more about the three amigos. My colleagues mentioned two of the three amigos, Amigo Volker and Amigo Sondland. These are two of the three people that the president put in charge of Ukraine policy. The third amigo is Secretary Rick Perry, the former Secretary of Energy. Well, we know from Amigo Sondland's testimony that he was certainly in the loop. He knew exactly all about this scheme. And we know from Ambassador Volker's testimony and his text messages and his WhatsApps that amigo was in the loop. What about the third amigo? Wouldn't you like to know if the third amigo was in the loop? Now, as my colleagues will explain, when we get to the Department of Energy records, that, well, surprisingly, we didn't get those either. But any communication between the Department of Energy and the Department of State is covered by this amendment. Wouldn't you like to know? Don't you think the American people have a right to know what the third amigo knew about this scheme? I'd like to know. I think you should be able to ask questions about it in your 16 hours. At the end of the day, I guess I'll finish with something Mr. Sekulow said. He said, this was a dangerous moment because we're trying to rush through this somehow. It is a dangerous moment, but we're not trying to rush through this trial. We're actually trying to have a real trial here. It's the president that's trying to rush through this. And I have to tell you that whatever you decide here, maybe this is wasted breath and maybe it's already decided, but whatever you decide here, I don't know who the next president's going to be. Maybe it'll be someone in this chamber. But I guarantee you this, whoever that next president is, whether they did something right or they did something wrong, there's going to come a time where you in this body are going to want to subpoena that president and that administration. You're going to want to get to the bottom of serious allegations. Are you prepared to say that that president can simply say, I'm going to fight all subpoenas? Are you prepared to say and accept that president saying, I have absolute immunity. You want me to come testify? Senator, you want me to come and testify? No. I have absolute immunity. You can subpoena me all you like. I'll see you in court. And when you get to court, I'm going to tell you, you can't see me in court. Are you prepared for that? That's what the future looks like. Don't think this is the last president if you allow this to happen. That's going to allow this to take place.
Your time
Mr. Justice, I yield back, I think.
Congressman Adam Schiff, Democrat from California, House Impeachment Manager.
The Majority Leader is recognized.
To table the amendment.
The question is on the motion to table.
And ask the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Chief Justice John Roberts presiding.
Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capiccio, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
The U.S. Senate vote to table or kill an amendment to subpoena relevant State Department documents and records. The Senate considering amendments to a resolution governing how the impeachment trial of President Donald Trump will take place. This is live. And as the clerk tallies things up, this is the second amendment so far offered. The first one was to subpoena documents from the White House, and that failed. It was tabled or killed by a vote of 53 to 47. this vote could be similar. And we will note here on C-SPAN Radio that the video and the audio coming from the Senate is controlled by the Senate. So as this vote tally is finishing up, that's why you're not hearing anything in the background. Here's the Chief Justice John Roberts now with the vote total.
Is there anyone wishing to vote or change their vote? If not, the yeas are 53, the nays 47. The motion to table is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain office and management and budget documents, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment number 1286. At the appropriate place in the resolving clause, insert the following section: notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the acting director of the Office of Management and Budget, commanding him to produce for the time period from January 1st, 2019 to the present all documents, communications, and other records within the possession, custody, or control of the Office of Management and Budget referring or relating to A, the actual or potential suspension, withholding, delaying, freezing, or releasing of the United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, referred to in this section as USAI, and foreign military financing, referred to in this section as FMF, including but not limited to 1, communications among, between, or referring to Director Michael John Mick Mulvaney, Assistant to the President Robert Blair, Acting Director Russell Vaught, Associate Director Michael Duffy, or any other Office of Management and Budget employee. 2, communications related to requests by President Trump for information about Ukraine's security or military assistance and responses to those requests. 3, communications related to concerns raised by any Office of Management and Budget employee related to the legality of any hold on foreign assistance, military assistance, or security assistance to Ukraine. 4, communications sent to the Department of State regarding a hold or block on congressional notifications regarding the release of FMF funds to Ukraine. 5, communications between 1, officials at the Department of Defense, including but not limited to Undersecretary of Defense Elaine McCusker, and 2, Associate Director Michael Duffy, Deputy Associate Director Mark Sandy, or any other Office of Management and Budget employee. 6, all draft and final versions of the August 7th, 2019 memorandum prepared by the National Security Division, International Affairs Division, and Office of General Counsel of the Office of Management and Budget about the release of foreign assistance, security assistance, or security assistance to Ukraine. 7, the Ukrainian government's knowledge prior to August 28th, 2019 of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance to Ukraine, including all meetings, calls, or other engagement with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. B, communications, opinions, advice, counsel, approvals, or concurrences provided by any employee in the Office of Management and Budget regarding the actual or potential suspension, withholding, delaying, freezing, or releasing of security assistance to Ukraine, including legality under the Impoundment Control Act. C, Associate Director Michael Duffy taking over duties related to apportionments of USAI FMF from Deputy Associate Director Mark Sandy or any other Office of Management and Budget employee. D, all meetings related to the security assistance to Ukraine, including but not limited to interagency meetings on July 18th, 2019, July 23rd, 2019, July 26, 2019, and July 31st, 2019, including any directions provided to staff participating in those meetings and any readouts from those meetings. E, the decision announced on or about September 11, 2019, to release appropriated foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to any notes, memoranda, documentation, or correspondence related to the decision. F, all draft and final versions of talking points related to the withholding or release of foreign assistance, military assistance, or security assistance to Ukraine, including communications with the Department of Defense related to concerns about the accuracy of the talking points, and G, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York, and 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Senate Clerk reading the amendment offered by Senate Minority Leader Chuck Schumer.
Mr. Chief Justice.
The Majority Leader is recognized.
Mitch McConnell.
Scheduling note, as the parties are ready to debate this amendment, I suggest we go ahead, get through the debate, and vote before we take a 30-minute recess for dinner. And I would remind everyone that I'll be moving to table the amendment, and it's also important to remember that both evidence and witnesses are addressed in the underlying resolution.
Thank you. The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent of the motion? Proponent. Mr. Cipollone, are you a proponent or opponent? Then, Mr. Schiff, your side will proceed first, and you will be able to reserve time for rebuttal.
Chief Justice John Roberts presiding.
Before I begin, Mr. Chief Justice, the House managers will reserve the balance of our time to respond to the counsel for the President. Mr. Chief Justice, Senators, Counsel for the President, and the American people, I am Jason Crow from the great state of Colorado. The House managers strongly support this amendment to subpoena key documents from the Office of Management and Budget, or OMB. These documents go directly to one of President Trump's abuses of power, his decision to withhold vital military aid from a strategic partner that's at war to benefit his own personal re-election campaign. But why should that matter? Why should anybody care? Why should I care? Before I was a member of Congress, I was an American soldier, serving in Iraq and Afghanistan. And although some years have passed since that time, there are still some memories that are seared in my brain. One of those memories was scavenging scrap metal on the streets of Baghdad in the summer of 2003 that we had to bolt onto the side of our trucks because we had no armor to protect against roadside bombs. So when we talk about troops not getting the equipment that they need when they need it, it's personal to me. To be clear, here we are talking of $391 million of taxpayer money intended to protect our national security by helping our strategic partner, Ukraine, fight against Vladimir Putin's Russia, an adversary of the United States. But the president could not carry out this scheme alone. He needed a lot of people to help him. And that's why we know as much about it as we do today. But there is much more to know. And that's what trials are for, to get the full picture. We know there's more because President Trump needed the Office of Management and Budget to figure out how to stop what should have been a routine release of funds mandated by Congress. A release of funds that was already underway. But the people in this chamber don't need me to tell you that, because 87 of you in this room voted for those vital funds to support our partner, Ukraine. Witnesses before the House testified extensively about OMB's involvement in carrying out the hold. It was OMB that relayed the president's instructions and implemented the hold. And it was OMB that scrambled to justify the freeze. OMB has key documents that President Trump has refused to turn over to Congress. It is time to subpoena those documents. These documents would provide insight into critical aspects of the military aid hold. They would show the decision-making process and motivations behind President Trump's freeze. They would reveal the concerns expressed by career OMB officials, including lawyers, that the hold was violating the law. They would expose the lengths to which OMB went to justify the president's hold. They would reveal concerns about the impact of the freeze on Ukraine and U.S. national security. And they would show that senior officials repeatedly attempted to convince President Trump to release the hold. In short, they would show exactly how the president carried out the scheme to use our national defense funds to benefit his personal political campaign. We are not speculating about the existence of these documents. We are not guessing what the documents might show. During the course of the investigation in the House, witnesses who testified before the committees identified multiple documents directly relevant to the impeachment inquiry that OMB continues to hold to this day. We know these documents exist, and we know that the only reason we do not have them is because the president directed OMB not to produce them, because he knows what they would show. To demonstrate the significance of the OMB documents and the value they would provide in this trial, I would like to walk you through some of what we know exists, but which the Trump administration has refused to turn over. As we have discussed, the Trump administration has refused to turn over any documents to the House in response to multiple subpoenas and requests. Based on what is known from the testimony and the few documents that have been obtained through public reporting and lawsuits, it's clear that the president is trying to hide this evidence because he is afraid of what it would show. The documents offer stark examples of the chaos and confusion that the president's scheme set off across our government. And they make clear the importance of the documents that are still being concealed by the president. We know that OMB has documents that reveal that as early as June, the president was considering holding military aid for Ukraine. The president began questioning military aid to Ukraine after Congress appropriated and authorized the money. $250 million in DoD funds and $141 million in State Department funds. This funding had wide bipartisan support because, as many witnesses testified, providing military aid to Ukraine to defend itself against Russian aggression also benefits our own national security. Importantly, the President's questions came weeks after the Department of Defense already certified that Ukraine had undertaken the anti-corruption reforms and other measures mandated by Congress as a condition for receiving that aid.
Congressman Jason Crow, House Impeachment Manager.
So there is a process for making sure that the funds make it to the right place and to the right people. A process that has been followed every year that we have been providing that security assistance to Ukraine, including the first 2 years under the Trump administration. Nonetheless, the President's questions came days after DoD issued a press release on June 18th announcing it would provide its $250 million portion of the taxpayer-funded military aid to Ukraine. According to public reporting, the day after DoD's press release, a White House official named Robert Blair called OMB's acting director, Russell Vought, to talk about the military aid to Ukraine. According to public reports, Mr. Blair told Vought, quote, "We need to hold it up." OMB has refused to produce any documents related to this conversation. The Senate can get them by passing the amendment and issuing a subpoena. But there's more. The same day Blair told Vought to hold up the aid, Michael Duffy, a political appointee at OMB who reports to Vought, emailed Deputy Undersecretary of Defense Elaine McCusker and told her that the President had questions about the aid. Duffy copied Mark Sandy, a career official at OMB, who told us about the email in his testimony before the House. Like all others, that email was not produced by the Trump administration in the House impeachment investigation. We know this email exists, however, because in response to a Freedom of Information Act lawsuit, the Trump administration was forced to release a redacted email consistent with Sandy's description. But OMB provided none of those documents to the House. With this proposed amendment, the Senate has an opportunity to obtain and review the full record that could further demonstrate how and why the President was holding the aid. These documents would also shed light on the President's order to implement the hold. On July 3rd, the State Department told various officials that OMB blocked it from dispensing $141 million in aid. OMB had directed the State Department not to send a notification to Congress about spending the money. And without that notification, the aid was effectively blocked. Why did OMB block the congressional notification? Who told them to do it? What was the reason? The Senate would get those answers if it issued this subpoena. But there's more. On July 12th, Blair, the White House official who had called Vought on June 19th and said, quote, "We need to hold it up," then sent an email to Duffy at OMB. Blair said, quote, "The President is directing a hold on military support funding for Ukraine." We haven't seen this email. The only reason we know about it is from the testimony of Mark Sandy, the career OMB official who followed the law and complied with his subpoena. As you can see from the transcript excerpt in front of you, Sandy testified that the July 12th email did not mention concerns about any other country or any other aid packages, just Ukraine. So of the dozens of countries where we provide aid and support, the President was only concerned about one of them, Ukraine. Why? Well, we know why. But OMB has still refused to provide a copy of this July 12 email and has refused to provide any documents surrounding it, all because the President told OMB to continue to hide the truth from Congress and the American people. What was he afraid of? A subpoena issued by the Senate would show us. OMB also has documents about a key series of meetings triggered by the President's order to hold the military aid. In the second half of July, the National Security Council convened a series of interagency meetings about the president's hold on military aid. OMB documents would show what happened during those meetings. For example, on July 18th, the National Security Council staff convened a routine interagency meeting to discuss Ukraine policy. During the meeting, it was the OMB representative who announced that President Trump placed a hold on all military aid to Ukraine. Ambassador Bill Taylor, our most senior diplomat to Ukraine, participated in that meeting. And he described his reaction at his open hearing.
In a regular NSC secure video conference call on July 18th, I heard a staff person from the Office of Management and Budget say that there was a hold on security assistance to Ukraine, but could not say why. Toward the end of an otherwise normal meeting, a voice on the call, the person was off screen, said that she was from OMB and her boss had instructed her not to approve any additional spending on security assistance for Ukraine until further notice. I and others sat in astonishment. The Ukrainians were fighting Russians and counted on not only the training and weapons, but also the assurance of U.S. support. All that the OMB staff person said was that the directive had come from the President to the Chief of Staff to OMB. In an instant, I realized that one of the key pillars of our strong support for Ukraine was threatened.
It's hard to believe that OMB would not have any documents following this bombshell announcement. It surely does. It was the agency that delivered the shocking news to the rest of the U.S. government that the President was withholding the vital military aid from our partner. And we would see these documents if the Senate issued a subpoena. The July 18th meeting was just the first in a series of meetings where OMB held the line and enforced the President's hold on the aid. But there was a second meeting on July 23rd where we understood agencies raised concerns about the legality of OMB's hold on the aid. And then a third meeting at a more senior level on July 26th. Witnesses testified that at that meeting, OMB struggled to offer an explanation for the President's hold on the aid. And then a fourth meeting on July 31st where the legal concerns about the hold were raised. At each of these meetings, there was confusion about the scope and the reasons for the hold. Nobody seemed to know what was going on. But that was exactly the point. All of the agencies, except OMB, which was simply conveying the President's order, supported the military aid and argued for lifting the hold. OMB did not produce a single document providing information about its participation, preparation, or follow-up from any of these meetings. Did these OMB officials come prepared with talking points for these meetings? Did OMB officials take notes during any of these meetings? Did they exchange emails about what was going on? Did OMB discuss what reasons they could give everyone else for the hold? By issuing this subpoena, the Senate can find out the answers to all of those questions and others like them. The American people deserve answers. OMB documents would also reveal key facts about what happened on July 25th. On July 25th, President Trump conducted his phone call with President Zelensky, during which he demanded a favor. This favor was for Ukraine to conduct an investigation to benefit the president's re-election campaign. That call was at 9 a.m. Just 90 minutes after President Trump hung up the phone, Duffy, the political appointee at OMB, who is in charge of national security programs, emailed DOD to, quote, formalize, end quote, the hold on the military aid. Just 90 minutes after President Trump's call, a call in which the president had asked for a favor. That email is on the screen in front of you. We have a redacted copy of this email because it was recently released through the Freedom of Information Act. It was not released by the Trump administration in response to the House's subpoena. In this email, Duffy told the DOD officials that based on the guidance he had received, they should, quote, hold off on any additional DOD obligations of these funds. He added that the request was, quote, sensitive, and that they should keep this information closely held, meaning don't tell anybody about it.
Congressman Jason Crow, Democrat and House Impeachment Manager, on the Senate floor. Live, WCSP-FM, Washington.
Why did Duffy consider the information sensitive? Why didn't he want anyone to learn about it? Answers to those questions may be found in OMB emails that we could all see if you issue a subpoena. But there's more. Remember, the administration needed to create a way to stop funding that was already underway. The train had already left the station. And something like this had never been done before. Later in the evening of July 25th, OMB found a way, even though DOD had already notified Congress that the funds would be released. Here is how the scheme worked. OMB sent DOD a funding document that included a carefully worded footnote directing DOD to hold off on spending the funds. Quote, to allow for an interagency process to determine the best use, end quote. Remember that language. To allow for an interagency process to determine the best use. Let me explain that. The footnote stated that this, quote, brief pause would not prevent DOD from spending the money by the end of the fiscal year, which was coming up on September 30th. OMB had to do this because it knew that not spending the money was illegal. And they knew that DOD would be worried about that. And they were right. DOD was worried about it. Mr. Sandy testified that in his 12 years of experience at OMB, he could not recall anything like this ever happening before. The drafting of this unusual funding document and the issuance of the document must have generated a significant amount of email traffic, memos, and other documentation at OMB. Memos, email traffic, and documentation that we would all see if the Senate issued a subpoena. So what was the result from the series of events on July 25th? Where was Mr. Duffy's guidance to implement the hold coming from? Why was the request sensitive? What was the connection between OMB's direction to DOD and the call President Trump had with President Zelensky just 90 minutes before? Did agency officials communicate about the questions coming from Ukrainian officials? The American people deserve answers. A subpoena would provide those answers. OMB documents also would reveal information about the decision to have a political appointee take over Ukraine funding responsibility. The tensions and chaos surrounding the freeze escalated at the end of July when Duffy, a political appointee at OMB, with no relevant experience in funding approvals, took authority for releasing military aid to Ukraine away from Sandy, a career OMB official. Sandy could think of no other example of a political appointee taking on this responsibility. Sandy was given no reason other than that Mr. Duffy wanted to be, quote, more involved in daily operations, end quote. During his deposition, Sandy confirmed that he was removed from the funding approval process after he had raised concerns to Duffy about whether the hold was legal under the Impoundment Control Act. Needless to say, OMB has refused to turn over any documents or communications involving that decision to replace Mr. Sandy. Why did Duffy, a political appointee with no relevant experience in this area, take over responsibility for Ukraine funding approval? Was the White House involved in that decision? Was Sandy removed because he had expressed concerns about the legality of the hold? By August 7th, people in our government were worried. And when people in the government get worried, sometimes what they do is they draft memos. Because when they're concerned about getting caught up in something that doesn't seem right, They don't want to be a part of it. So on that day, Mark Sandy and other colleagues at OMB drafted and sent a memo about Ukraine military aid to Acting Director Vaught. According to Sandy, the memo advocated for the release of the funds. It said that the military aid was consistent with American national security interests. It would help to oppose Russian aggression, and it was backed by strong bipartisan support. But President Trump did not lift the hold. Over the next several weeks, OMB continued to issue funding documents that kept kicking the can down the road, supposedly to allow for more of this, quote, interagency process, while inserting those footnotes throughout the apportionment documents stating that the delay wouldn't affect the funding. But here's the really shocking part. There was no interagency process. They made it up. It had ended months before. They made it up because nobody could say the real reason for the hold. In total, OMB issued 9 of these documents between July 25th and September 10th. Did the White House respond to OMB's concerns and recommendation to release the aid? Did the White House instruct OMB to continue creating a paper trail in an effort to justify the hold? Who knew what and when? OMB documents would shed light on OMB's actions as the president's scheme unraveled. Did the White House direct OMB to continue issuing the hold? What was OMB told about the president's reasons for releasing the hold? What communications did OMB officials have with the White House around the time of the release? As the president's scheme unraveled, did anyone at OMB connect the dots about the real reason for the hold? The OMB documents would shed light on all of these questions, and the American people deserve answers.
Democratic Congressman Jason Crow, House Impeachment Manager.
I remember what it feels like to not have the equipment you need when you need it. Real people's lives are at stake. That's why this matters. We need this information so we can ensure that this never happens again. Eventually, this will all come out. We will have answers to these questions. The question now is whether we'll have them in time and who here will be on the right side of history.
Mr. Sekulow?
Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the President's argument.
Thank you. Mr. Sekulow?
Presiding is Chief Justice John Roberts, and now Jay Sekulow, personal attorney to President Donald Trump.
Thank you, Mr. Chief Justice, members of the Senate. Manager Crow, you should be happy to know that the aid that was provided to Ukraine over the course of the President's administration included lethal weapons. Those were not provided by the previous administration. The suggestion that the Ukraine failed to get any equipment is false. The security assistance was not for funding Ukraine over the summer of 2019. There was no lack of equipment due to the temporary pause. It was future funding. The Ukraine Deputy Minister of Defense who oversaw U.S. aid shipments said the hold came and went so quickly they did not notice any change. Undersecretary of State David Hale explained the paused aid was future assistance, not to keep the Army going now. So the made-up narrative that security assistance was conditioned on Ukraine taking some action on investigations is further disproved by the straightforward fact that the aid was delivered on September 11th, 2019, without Ukraine taking any action on any investigation. It's interesting to note that the Obama administration withheld $585 million of promised aid to Egypt in 2013. But the administration's public message was that the money was not officially on hold, as technically it was not due until September 30th, the end of the fiscal year. So they didn't have to disclose the halt to anyone. Sounds like this may be a practice of a number of administrations. In fact, to the president, this president has been concerned about how aid is being put forward. So there have been pauses on foreign aid in a variety of contexts. In September of 2019, the administration announced that it was withholding over $100 million in aid to Afghanistan over concerns about government corruption. In August of 2019, President Trump announced that the administration and Seoul were in talks to substantially increase South Korea's share of the expense of U.S. military support for South Korea. In June, President Trump paused over $550 million in foreign aid to El Salvador, Honduras, and Guatemala because those countries were not fairly sharing the burdens of preventing mass migration to the United States. This is not the only administration. As I said, President Obama withheld hundreds of millions of dollars of aid to Egypt. To be clear, and I want to be clear, Ambassador Yovanovitch herself testified that our policy actually got stronger under President Trump, largely because, unlike the Obama administration, quote, this administration made the decision to provide lethal weapons to Ukraine to help Ukraine fend off Russian aggression. She testified in a deposition before your various committees that, and actually I felt that in the 3 years that I was there, partly because of my efforts, but also the interagency team and President Trump's decision to provide lethal weapons to Ukraine, that our policy actually got stronger. Deputy Assistant Secretary Kent, his name's come up a couple of times, agreed that javelins are incredibly effective weapons at stopping armored advance, and the Russians are scared of them. Ambassador Volker explained that President Trump approved each of the decisions made along the way, and as a result, America's policy towards Ukraine strengthened. So when we want to talk about facts, go to your own discovery and your own witnesses that you called. This all supposedly started because of a whistleblower. Where is that whistleblower?
Jay Sekulow, President Donald Trump's personal attorney. U.S. Senate on C-SPAN Radio.
The House managers have 35 minutes remaining.
Returning is Congressman Jason Crow.
Mr. Chief Justice, at war, time matters. Minutes and hours can seem like years. So the idea that, well, it made it there eventually just doesn't work. And yes, the aid was provided. It was provided by Congress, this Senate, and the House of Representatives with the President's signature. The Congress is the one that sends the aid. And millions of dollars of this aid would have been lost because of the delay had Congress not actually passed another law that extended that deadline to allow the funds to be spent. Let me repeat that. The delay had jeopardized the expenditure of the money to such an extent that Congress had to pass another law to extend the deadline so that the money and the equipment got to the people on the front lines. Need I also reiterate the supposed interagency process, the concerns that the President and his counsel continue to raise about corruption and making sure that the process went right. There was no interagency process. The whole thing was made up. It was a phantom. There was a delay, and delays matter. Mr. Chief Justice, I reserve the balance of my time for Mr. Schiff.
Mr. Schiff?
Thank you, Mr. Chief Justice. Just a few additional points I'd like to make on this amendment and on my colleagues' arguments. First of all, Mr. Sekulow makes the point that the aid ultimately got released. They ultimately got the money, right? Yes, they got the money after the president got caught, after the president was forced to relieve the hold on the aid, after he got caught, yes. But even then they had held on to the aid so long that it took a subsequent act of Congress to make sure it could all go out the door. So what, is the president supposed to get credit for that we had to intervene because he withheld the aid so long? And that's the only reason Ukraine got all of the aid that we'd approved in the first place? My colleagues have glossed over the fact that what they did was illegal, that the GAO, an independent watchdog agency, found that that hold was illegal. So it not only violated the law, it not only took an act of Congress to make sure they ultimately got the aid. This is supposed to be the defense to why you shouldn't see the documents? Is that what we're to believe? Now, counsel also says, well, he's not the first president to withhold aid. And that's true. After all, counsel says, well, President Obama withheld aid to Egypt. Yes, at the urging of members of Congress. Senators McCain and Graham urged that aid be withheld. And why? Because there was a revolution in Egypt after it was appropriated. That wasn't something that was hidden from Congress. That was a pretty darn good reason to think that we still want to give aid to this government after this revolution. We're not saying that aid has never been withheld. That's absurd. But I would hope and expect this is the first time aid has been withheld by a president of the United States to coerce an ally at war to help him cheat in the next election. I think that's a first. But what we do here may determine whether it's the last. And one other thing about this pause in aid, right? The argument, well, no harm, no foul. Okay, you got caught, they got the aid. What's the big deal? Well, as we heard during the trial, it's not just the aid. I mean, the aid is obviously the most important thing. As Mr. Crow mentioned, without it you can't defend yourself, and we'll have testimony about just what kind of military aid the president was withholding. But we also had testimony that it was the fact of the aid itself that was so important to Ukraine. The fact that the United States had Ukraine's back. And why? Because this new president of Ukraine, this new untested former comedian, president of Ukraine, at war with Russia, was going to be going into a negotiation with Vladimir Putin with an eye to ending that conflict. And whether he went into that negotiation from a position of strength or a position of weakness would depend on whether we had his back. And so when the Ukrainians learned and the Russians learned that the President of the United States did not have his back, was withholding this aid, what message do you think that sent to Vladimir Putin? What message do you think it sent to Vladimir Putin when Donald Trump wouldn't let Vladimir Zelensky, our ally, in the door at the White House, but would let the Russian foreign minister? What message does that send? So it's not just the aid, it's not just when the aid is delivered, it's not just if all of the aid is delivered, it's also what message does the freeze send to our friend and, even more importantly, to our foe. And the message it sent was a disaster. Was a disaster. Now,
Congressman Adam Schiff, House Intelligence Committee Chair and Impeachment Manager.
You might ask yourself, because counsel has said, hey, President Trump has given lethal weapons to Ukraine. You might ask yourself, if the president was so concerned about corruption, why did he do that in 2017? And why did he do that in 2018? Why was it only 2019 that there was a problem? Was there no corruption in Ukraine in 2017? Was there no corruption in Ukraine in 2018? No. Ukraine has always battled corruption. It wasn't the presence or lack of corruption in one year to another. It was the presence of Joe Biden as a potential candidate for president. That was the key change in 2019. That made all the difference. But it gets back to one of the key moments in this saga. You know, a lot of you are attorneys. You're probably much better attorneys than I am. And I'm sure you had the experience in cases you tried where there was some vignette, some conversation, some document. It may not have been the most important on its face, but it told you something about the case that was much larger than that conversation. For me, one of those conversations was not on July 25th between President Trump and President Zelensky, but on July 26th, the very next day. Now, you may have watched some of the House proceedings, or you may haven't, and people watching may have seen it, maybe they didn't. But there's this scene in a Ukrainian restaurant, a restaurant in Kyiv, with Gordon Sondland. Now, bear in mind, Gordon Sondland, who said there was absolutely a quid pro quo and 2 + 2 = 4, this is not some never-Trumper. This is $1 million donor to the Trump inauguration, okay? If there's a bias there, it's clearly $1 million bias in favor of this president, not against him. So there's a scene in Kyiv, in this restaurant, and Sondland has a cell phone, and he's sitting with David Holmes, who is a career diplomat, U.S. diplomat in the Ukraine embassy. And Gordon Sondland takes out his phone and he calls the White House. Gordon Sondland holding for the White House. Gordon Sondland holding for the president. And it takes a while to be connected, but he's connected to the president. That's pretty impressive, right? This isn't some guy with no relationship to the president. The president may say, Gordon Sondland, I barely know him, or something to that effect, but this is a guy who can pick up his cell phone. He can call the president of the United States from a restaurant in Kyiv, and he does. And the president's voice is so loud that David Holmes, this diplomat, can hear it. And what does the president say? Does he say, how's that reform coming in the Rada? How's the attack on corruption going? No. He just says, is he going to do the investigation? Is Zelensky going to do the investigation? And Sondland says, yes. He'll do anything you want. He loves your ass. This is the extent of the president's interest in Ukraine, and they go on to talk about other things, and then they hang up. And David Holmes turns to the ambassador and says, in language which I will have to modify, to remove an expletive, says something along the lines of, does the president give a blank about Ukraine? And Sondland says, no. He doesn't give a blank about Ukraine. He only cares about the big stuff, like the investigation of the Bidens that Giuliani wants. This is $1 million donor to the Trump inaugural, admitting the president doesn't care about Ukraine. He doesn't care whether they get military dollars to defend themselves. He doesn't care about what position Zelensky goes into in these negotiations with Putin. He doesn't care about that. Isn't that clear? It's why he didn't care about corruption in 2017 or 2018, and he certainly didn't care about it in 2019. All he cared about was the big stuff that affected him personally, like this investigation that he wanted of the Bidens. So when you ask, do you want to see these documents? Do you want to know if these documents corroborate Ambassador Sondland? Will the documents show, as we fully expect they will, that the only thing he cared about was the big stuff that affected him. David Holmes' response was, well, you know, there's some big stuff going on here, like a war with Russia. This isn't withholding aid because of a revolution in Egypt. This is withholding aid from a country in which 15,000 people have died fighting the Russians. And as Ambassador Taylor said, and others, you know, Russia's fighting to remake the map of Europe by dint of military force. If we think that's just about Ukraine's security, we are very deceived. It's about our security. It's about the tens of thousands of troops that we have in Europe. And if we undercut our own ally, if we give Russia reason to believe we will not have their back, that we'll use Ukraine as a plaything, or worse, to get them to help us cheat in an election, that will only embolden Putin to do more. You've said it as often as I have, the only thing he respects is strength. Do you think that looks like strength to Vladimir Putin? I think that looks like something that Vladimir Putin is only too accustomed to. And that is the kind of corruption that he finds and he perpetuates in his own regime and he pushes all around the world. My colleague Val Demings made reference to a conversation which I think is one of the other key vignettes in this whole sad saga. And that's that conversation that Ambassador Volker has with Andrei Yermak, one of the top aides to President Zelensky. And this is a conversation in which Ambassador Volker is doing exactly what he's supposed to be doing, which is he's telling Yermak, you know, you guys shouldn't really do this investigation of your former President Poroshenko because it would be for a political reason. You really shouldn't engage in political investigations.
Congressman Adam Schiff, House Impeachment Manager, on the Senate floor.
As Representative Deming said, what's the response from Ukrainians? Oh, you mean like the one you want us to do of the Bidens and the Clintons? Threw it right back in his face. Ukraine's not oblivious to that hypocrisy. Mr. Secretary says, what are we here for? You know, part of our strength is not only our support for our allies, it's not only our military might, it's what we stand for. We used to stand for the rule of law. We used to champion the rule of law around the world. Part of the rule of law is, of course, that no one is above the law. But to be out in Ukraine or anywhere else in the world championing the rule of law and saying, don't engage in political prosecutions, and having them throw it right back in our face, oh, you mean like the one you want us to do. That's why we're here. That's why we're here. That's why we're here. I yield back.
U.S. Senate considering an amendment from the Senate Minority Leader Chuck Schumer to subpoena documents from the White House Budget Office. The underlying resolution sets the time and procedures for the impeachment trial.
Mr. Chief Justice.
The Majority Leader is recognized.
I send a motion to the desk to table the amendment and ask for the yeas and nays.
It's Mitch McConnell, the Senate Majority Leader.
Is there a sufficient second? There is. The clerk will call the roll.
Chief Justice John Roberts presiding.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
U.S. Senate considering a vote to table or kill an amendment to subpoena documents and records from the White House Budget Office related to the charges against President Donald Trump. U.S. Senate considering the organizing resolution for the impeachment trial. Clerk now tallying the vote. Previous votes regarding an effort to subpoena documents, first from the there was also one from the State Department and also from the White House itself. They both were tabled on a party line vote, 53 to 47. Republicans voting yes and Democrats voting no. We do expect this to be the same vote, and here's the Chief Justice, John Roberts, with the total.
The yeas are 53, the nays are 47. The motion is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to issue a subpoena to John Michael Mick Mulvaney, and I ask that it be read.
Clerk will report.
The Senate Democratic leader offering that amendment is Chuck Schumer.
The senator from New York, Mr. Schumer, proposes an amendment number 1287. At the appropriate place in the resolving clause, insert the following section: notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Michael Mick Mulvaney, and the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The majority leader is recognized.
I now ask for a 30-minute recess before the parties are recognized to debate the Schumer amendment. Following the debate time, I will once again move to table the amendment because votes on witnesses and evidence, as I've repeatedly said, are addressed in the underlying resolution. So I ask that the Senate stand in recess until 8 p.m.
Without objection, so ordered. Bang the cavalry.
Chief Justice John Roberts, presiding officer for the trial. U.S. Senate live on C-SPAN radio. So far today, they have brought up a resolution. Senate Majority Leader Mitch McConnell's brought up the resolution to design how the trial will go forward, how much time each side will have, over what length of days. And so far, the Senate Democratic leader Chuck Schumer has been trying to get documents subpoenaed. It's all been tabled or killed by the Republicans. And as you just heard, they'll be back at 8 p.m. Eastern to continue this debate. Now there's an amendment to subpoena the White House acting Chief of Staff, Mick Mulvaney. We expect this to go on through the evening here on C-SPAN Radio. During this dinner break, we bring you Washington Today.
This is not a process for a fair trial. This is the process for a rigged trial. This is the process if you do not want the American people to see the evidence. This is a process you use if you want to, hand in hand, working in concert with the President, allow the President to continue to obstruct the Congress and deny the truth to the American people.
Congressman Adam Schiff, one of the House Democratic managers, and the formal start of the impeachment trial of President Trump in the United States Senate, and a day with a lot of political drama.
The Senate will convene as a court of impeachment,
with the Chief Justice, John Roberts, presiding.
If there is no objection, the Journal of Proceedings of the trial are approved to date.
It is Tuesday, January 21st. This is an impeachment trial update on Washington Today. I'm Steve Scully. Much of the focus on the Senate rules. Mitch McConnell is the Republican leader.
The organizing resolution we'll put forward already has the support of a majority of the Senate. That's because it sets up a structure that is fair.
Those remarks bringing a quick response from the Senate's Democratic leader, Chuck Schumer.
Because the McConnell rules seem to be designed by President Trump for President Trump. Simply executed by Leader McConnell and Senate Republicans.
And among those representing the President, White House counsel Pat Cipollone.
The President was not allowed to have a lawyer present. In every other impeachment proceeding, the President has been given a minimal due process. Nothing here.
The story shaping Washington Today. It's all ahead on C-SPAN Radio. We, of course, begin on Capitol Hill after being sworn in last week. This was day one of the arguments and counter-arguments in the impeachment trial. Here's a recap of what happened early this afternoon to the Senate Republican leader backing off his proposed requirement that the House impeachment managers and the President's lawyers fit their opening arguments into 2-day windows, which could have forced the trial into the early morning hours. The Kentucky Republican amending his organizing resolution at the last minute to give each side 3 days to make up their opening arguments, which can last for up to 24 hours. That, by the way, is the same amount of time given to the prosecution and the defense during the 1999 impeachment trial of President Clinton 20 years ago.
It appears that Leader McConnell decided to go along with the President's desire to cover up his wrongdoing. Hook, line, and sinker. It almost seems that the resolution was written in the White House, not in the Senate.
On every point, our straightforward resolution will bring the clarity and fairness that everyone deserves. The President of the United States, the House of Representatives, and the American people. This is the fair roadmap for our trial. We need it in place before we can move forward. So the Senate should prepare to remain in session today until we complete this resolution and adopt it. This basic four-part structure aligns with the first steps of the Clinton impeachment trial in 1999. 21 years ago, 100 senators agreed unanimously that this roadmap was the right way to begin the trial. All 100 senators agreed the proper time to consider the question of potential witnesses was after opening arguments and senators' questions. Now, some outside voices have been urging the Senate to break with precedent on this question. Loud voices, including the leadership of the House majority, colluded with Senate Democrats and tried to force the Senate to pre-commit ourselves to seek specific witnesses and documents before senators had even heard opening arguments or even asked questions. These are potential witnesses, Mr. President, whom the House managers themselves declined to hear from, whom the House itself declined to pursue through the legal system during its own inquiry. The House was not facing any deadline. They were free to run whatever investigation they wanted to run. If they wanted witnesses who would trigger legal battles over presidential privilege, they could have had those fights. But the chairman of the House Intelligence Committee and the chairman of the House Judiciary Committee decided not to. They decided their inquiry was finished and moved right ahead. The House chose not to pursue the same witnesses they apparently would now like the Senate to pre-commit to pursuing ourselves. As I've been saying for weeks, nobody will dictate Senate procedure to United States senators. A majority of us are committed to upholding the unanimous, bipartisan Clinton precedent against outside influences with respect to the proper timing of these mid-trial questions.
The Republican leader also made another significant amendment, allowing the House impeachment inquiry to be entered into the Senate's official trial record, subject to some objections, something Senator McConnell declined to greenlight in his initial proposal. Now, the resolution also makes each side to choose how many people may make those arguments. A copy of the resolution provided to the press showing the changes added in a handwritten scrawl on the printed document. Senator McConnell had gotten pushback from a number of Republican colleagues on the draft during today's lunch meeting held shortly before the trial began at 1 p.m.
And so, Mr. Chief Justice, I send a resolution to the desk and ask that it be read.
The clerk will read the resolution.
TheHill.com is reporting that Senator McConnell changed his resolution to give prosecutors more time after a number of moderate senators, including Rob Portman of Ohio and Susan Collins of Maine, pushed back for some last-minute changes. More from the Senate floor, Democratic leader Chuck Schumer.
He said he wanted to get started in exactly the same way. It turns out, contrary to what the leader said, I'm amazed he could say it with a straight face, that the rules are the same as the Clinton rules. The rules are not even close to the Clinton rules. Unlike the Clinton rules, the McConnell resolution does not admit the record of the House impeachment proceedings into evidence. So Leader McConnell wants a trial with no existing evidence and no new evidence. A trial without evidence is not a trial. It's a cover-up. Second, unlike the Clinton rules, the McConnell resolution limits presentation by the parties to 24 hours per side over only 2 days. We start at 1, 12 hours a day, we're at 1 a.m., and that's without breaks. It'll be later. Leader McConnell wants to force the managers to make important parts of their case in the dark of night. Number 3, unlike the Clinton rules, the McConnell resolution places an additional hurdle to get witnesses and documents by requiring a vote on whether such motions are even in order. If that vote fails, then no motions to subpoena witnesses and documents will be in order. I don't want anyone on the other side to say, I'm going to vote no first on witnesses, but then later I'll determine it. If they vote for McConnell's resolution, they're making it far more difficult to vote in the future, later on in the trial. And finally, unlike the Clinton rules, the McConnell resolution allows a motion to dismiss at any time in the trial. So in short, contrary to what the leader has said, the McConnell rules are not at all like the Clinton rules. The Republican leader's resolution is based neither in precedent nor in principle. It is driven by partisanship and the politics of the moment. Today, I'll be offering amendments to fix the many flaws in Leader McConnell's deeply unfair resolution and seek the witnesses and documents we've requested, beginning with an amendment to have the Senate subpoena White House documents. Let me be clear. These amendments are not dilatory. They only seek one thing, the truth. That means relevant documents. That means relevant witnesses. That's the only way to get a fair trial. And everyone in this body knows it.
Much of the day was spent debating Senate rules, essentially the path forward in this trial. Amber Phillips of the Washington Post writing the following, quote, "For every Senate impeachment trial, the senators currently serving are the ones who decide how the trial will work. There are rules from the 1980s about how to run a Senate trial, but they are intentionally vague on some really important things, such as what kind of evidence can be shared and how long a trial should be. Senator McConnell is trying to avoid having to call witnesses for various reasons to largely boil down in protecting the president. He also wants a quick and speedy trial." More details at WashingtonPost.com. Here is the Senate Democratic leader, Chuck Schumer.
My Republican colleagues have offered several explanations for opposing witnesses and documents at the start of the trial. None of them has much merit. Republicans have said we should deal with the question of witnesses later in the trial. Of course, it makes no sense to hear both sides present their case first and then afterward decide if the Senate should hear evidence. The evidence is supposed to inform arguments, not come after they're completed. Some Republicans have said the Senate should not go beyond the House record by calling any witnesses. But the Constitution gives the Senate the sole power to try impeachments, not the sole power to review, not the sole power to rehash, but to try. Republicans have called our request for witnesses and documents political. If seeking the truth is political, then the Republican Party is in serious trouble.
So why the rush to speed through an impeachment trial? For Republicans, the goal is twofold: to quickly end a dramatic trial involving the president, also keeping the calendar in mind, including the State of the Union address slated for Tuesday, February 4th. Here is Senator McConnell.
The Senate agreeing to pick up and carry on the House's inadequate investigation would set a new precedent that could incentivize frequent and hasty impeachments from future House majorities. It could dramatically change the separation of powers between the House and the Senate if the Senate agrees we will conduct both the investigation and the trial of an impeachment. What's more, some of the proposed new witnesses include executive branch officials whose communications with the President and with other executive branch officials lie at the very core of the President's constitutional privilege. Pursuing those witnesses could indefinitely delay the Senate trial and draw our body into a protracted and complex legal fight over presidential privilege. Such litigation could potentially have permanent repercussions for the separation of powers and the institution of the presidency that senators would need to consider very, very carefully.
And now to the lead arguments for and against impeachment. Jay Sekulow is one of the president's lawyers.
When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get 2 articles of impeachment. 2 articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you today, who have said that executive privilege and constitutional privileges have no place in these proceedings. On June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, the White House assertion of privilege is backed by decades of precedent that has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides. Indeed, that's correct. Not because Manager Schiff said it, but because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt. What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the President was sworn into office, there was a desire to see him removed? I remember in the Mueller report, there were discussions about, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today. That day was a year ago. That day was in July when Special Counsel Mueller testified.
One of the leading House Democratic managers is California Congressman Adam Schiff, chairman of the House Intelligence Committee, responding to the president's lawyers, including Jay Sekulow.
Let me be very blunt. Right now, a great many, perhaps even most Americans do not believe there will be a fair trial. They don't believe that the Senate will be impartial. They believe that the result is pre-cooked. The president will be acquitted. Not because he is innocent, he is not, but because the senators will vote by party and he has the votes. The votes to prevent the evidence from coming out, the votes to make sure the public never sees it. The American people want a fair trial. They want to believe their system of government is still capable of rising to the occasion. They want to believe that we can rise above party and do what's best for the country, but a great many Americans don't believe that will happen. Let's prove them wrong. Let's prove them wrong. How? By convicting the president? No. Not by conviction alone. By convicting him if the House proves its case, and only if the House proves its case. But by letting the House prove its case, by letting the House call witnesses, by letting the House obtain documents, by letting the House decide how to present its own case and not deciding it for us. In sum, by agreeing to a fair trial.
By the way, while today's trial was getting underway, the president was overseas. He is attending the World Economic Forum in Davos, Switzerland.
We're bringing back tremendous business in the United States, and they're all here to see. I'll be making a speech, and then we'll be leaving shortly. But I think it's very important. The other's just a hoax. It's the witch hunt that's been going on for years, and frankly, it's disgraceful.
On the Senate floor, this defense of the president from Pat Cipollone, the White House counsel.
Let's remember how we all got here. They made false allegations about a telephone call. The President of the United States declassified that telephone call and released it to the public. How's that for transparency? When Mr. Schiff found out that there was nothing to his allegations, he focused on the second telephone call. He made false, and his colleagues made false allegations about that second telephone call that occurred before the one he had demanded. So the President of the United States declassified and released that telephone call. Still nothing. Again, complete transparency in a way that, frankly, I'm unfamiliar with any precedent of any President of the United States releasing a classified telephone call with a foreign leader. When Mr. Schiff saw that his allegations were false, and he knew it anyway, what did he do? He went to the House, and he manufactured a fraudulent version of that call. He manufactured a false version of that call. He read it to the American people, and he didn't tell them it was a complete fake. Do you want to know about due process? I'll tell you about due process. Never before in the history of our country has a president been confronted with this kind of impeachment proceeding in the House. It wasn't conducted by the Judiciary Committee. Now, Mr. Nadler, when he applied for that job, told his colleagues when they took over the House that he was really good at impeachment. But what happened was the proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present. In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF. Information was selectively leaked out. Witnesses were threatened. Good public servants were told that they would be held in contempt. They were told that they were obstructing. What does Mr. Schiff mean by obstructing? He means that unless you do exactly what he says, regardless of your constitutional rights, then you're obstructing. The president was not allowed to call witnesses. By the way, there's still evidence in the SCIF that we haven't been allowed to see. I wonder why.
Those remarks from the White House counsel. Now, during the Senate trial, the House Intelligence Committee Chair Adam Schiff denouncing the president's unwillingness to allow any witnesses at his impeachment trial, arguing that the acting chief of staff Mick Mulvaney, the former National Security Advisor John Bolton, and others should testify, particularly after the president himself said he would allow it. In fact, Chairman Schiff playing video of the president saying just that. And then there was this.
So you'll hear these lengthy presentations from the House. There will be a question and answer period for the senators, and then and only then, after essentially the trial is over, after the briefs have been filed, after the arguments have been made, after the senators exhaust all their questions, only then will the Senate consider whether to subpoena crucial documents and witness testimony that the president has desperately tried to conceal from this Congress and the American people. Documents and witness testimony that, unlike the Clinton trial, have not yet been seen or heard. It is true that the record compiled by the House is overwhelming. It is true the record already compels the conviction of the President. In the face of unprecedented resistance by the President, the House assembled a powerful case, evidence of the President's high crimes and misdemeanors. That includes direct evidence and testimony of officials who were unwilling and unwitting in this scheme and saw it for what it was. Yet there is still more evidence, relative and probative evidence, that the President continues to block, that would flesh out the full extent of the President's misconduct and those around him. We have seen that over the past few weeks, new evidence has continued to come to light, as the Nonpartisan Government Accountability Office has determined that the hold on military to Ukraine was illegal and broke the law. As John Bolton has offered to testify in the trial, as one of the President's agents, Lev Parnas, has produced documentary evidence that clarifies Mr. Giuliani's activities on behalf of the President and corroborates Ambassador Sondland's testimony that everyone was in the loop. As documents released under the Freedom of Information Act have documented the alarm at the Department of Defense while the President illegally withheld military support for Ukraine, an ally at war with Russia, without explanation. As a senior Office of Management and Budget official, Michael Duffy instructed Defense Department officials on July 25th, 90 minutes after President Trump spoke by phone with President Zelensky, the Defense Department should pause all obligation of Ukraine military assistance under its purview. 90 minutes after that call. Duffy added, quote, "Given the sensitive nature of the request, I appreciate your keeping that information closely held to those who need to know to execute the direction." Although the evidence is already more than sufficient to convict, there is simply no rational basis for the Senate to deprive itself of all relevant information in making such a hugely consequential judgment. Moreover, as the President's answer to his summons and his trial brief make clear, the President now attempts to contest the facts, albeit in false and misleading ways. But the President should not have it both ways. He should not be permitted to claim that the facts uncovered by the House are wrong, while also concealing mountains of evidence that bear precisely on those facts.
As the Senate impeachment trial continues, it is live on C-SPAN 2. You can listen to it anytime on the free C-SPAN radio app, of course live here on C-SPAN radio. The trial is front and center in the 2020 Democratic presidential primary, with a new ad released earlier today from the Michael Bloomberg campaign.
I am running to defeat Donald Trump. In 2016, I warned that Donald Trump was a dangerous demagogue. And when the Republican Congress wouldn't hold him accountable, I went to work helping run winning campaigns in 21 House seats. It's time for the Senate to act and remove Trump from office. And if they won't do their jobs this November, you and I will. I'm Mike Bloomberg, and I approve this message.
While the White House and the President's lawyers are focusing on the impeachment trial this week, the President's campaign focused on the 2020 election. There is this headline at Politico.com, voters giving the President's job performance low marks. Joining us on the phone is Stephen Shepard. He is chief polling analyst for Politico. First of all, tell us about the survey and what's the headline?
So this is something we've done the past couple of years to mark the anniversary of the president's inauguration. Obviously, it was January 20th, 2017, when he was sworn into office. His term will expire on January 20th, 2021. So this is sort of the third quarter, transitioning into the fourth of 4 years as president. So we've been doing this report card. We ask voters essentially, along with our partners at Morning Consult, to give the president a letter grade, both overall for his performance and then on a series of 10 different issues. And the results are pretty illuminating. And as you might expect, there were a lot more voters early in his term who were willing to give him an incomplete. And now as we hit the sort of final quarterly report card of the first term before the final one next year, we're down to very few kind of undecided voters when it comes to the president's job performance.
So let's break it down a little bit first with regard to jobs, the economy, and fighting terrorism. Between 42 to 46% give the president an A or a B. So that's pretty good.
Yeah, and those are his best issues, both on jobs and the economy. 46% give him an A or a B. Another roughly 15% give him a C. Just about a third give him a D or an F. Those are pretty good numbers. They certainly compare much better than some of the, which I'm sure you'll want to get into here in this conversation, some of his weaker issues, including some that have been a problem for the president and his administration and his political party, and as a liability going forward. But certainly jobs and the economy are things that the American public judges him better on, and are certainly things you mentioned his reelection campaign, certainly things that I think we can expect to hear a lot about over the next 10 months leading into November.
We're talking with Stephen Shepard. He is the chief polling analyst for Politico on the issues of international trade, immigration, foreign relations, the national debt, health care, draining the swamp, and climate change, global warming. A majority of those surveyed would give the president a D or an F. Not so good in those areas.
No. And, you mentioned climate change and global warming. That's not a surprise given the fact that the president has denied the existence of climate change and called it a hoax on occasion. Draining the swamp, obviously a major slogan of the president's first campaign, but only 24% of voters give him an A or a B rating on that. Healthcare, I mean, there was probably no greater issue at stake in the 2018 midterms. Probably explains a lot of Democrat success is running on health care in the 2018 midterms. Only 27% of voters give President Trump an A or a B. 50% give him a D or an F. The national debt, which has continued to explode, the numbers are virtually identical. On foreign relations, now more in the news as the country sees tensions with Iran escalate. Only 33% give Trump an A or a B, 51% give him a D or an F. At the same time, we've seen the country kind of test a lot of its alliances. These are the grounds that the president needs to reinforce his political standing, and this is probably for whoever the ultimate Democratic nominee is. This is probably where they want to focus their critiques of Trump.
And Stephen Shepard, how was the survey conducted?
The survey was conducted a week and a half ago via online interviews. We talked to roughly 2,000 registered voters. It's a pretty sizable sample, and one of the strengths of the poll, it allows us to kind of slice the data by political party and by other demographics, and you can check out all the results on our website at Politico.com.
Stephen Shepard, we thank you for being with us.
Thank you, Steve.
Washington Today can be heard every weekday on C-SPAN Radio, anytime on the free C-SPAN Radio app, and be sure to tune in Wednesday with more of the impeachment trial against President Trump. We thank you for listening.
WCSP-FM, Washington. And the Senate is coming back shortly. They're in a recess, a dinner break for the impeachment trial on this day. And when they come back, they will pick up with dealing with amendments to the organizing resolution. The resolution as presented by Senator McConnell, and it was slightly modified from what he originally presented, will allow each side, the House impeachment managers and the president's legal team, up to 24 hours to present their cases, now over 3 days instead of the original 2 days. Then 16 hours for senators to ask questions in writing through the Chief Justice, John Roberts presiding, and then 4 hours of debate and a vote on whether the Senate will even consider subpoenaing witnesses and documents. Well, so far today, the Senate Democratic leader Chuck Schumer has offered amendments to try to speed up that process on documents and witnesses. He wants documents first from the White House, and there was another amendment from the State Department, and a third one from the White House Budget Office. All were tabled or killed on party line votes, 53 to 47. He has now offered an amendment to subpoena the acting White House Budget Director, Mick Mulvaney. And that's where they'll pick up with the debate. Up to 2 hours of debate on that amendment when the Senate comes back in. They were due in at 8 o'clock Eastern, according to the Senate Majority Leader Mitch McConnell. It's now about 6 minutes after. They're not yet back. We'll go to the floor here on C-SPAN Radio as soon as they are. During this dinner break, a couple of senators came out and spoke with reporters. Here is Republican Ted Cruz.
Well, we're in the middle of day one of the impeachment trial, and I don't think it has been a good day for the House managers. We've seen the House managers and Senate Democrats making redundant motions over and over and over again, the same motions that are being rejected. And fundamentally, it is clear House Democrats view this as an opportunity to continue their partisan attacks on the president instead of focusing on the priorities of the American people. The Senate, at the end of the day, will go forward on an organizing resolution that is virtually identical to the resolution that began the Clinton impeachment trial. It is copied almost word for word from the Clinton impeachment trial, except in that instance, the organizing resolution was bipartisan. It was 100-0. Every Republican, every Democrat agreed. In this instance, Senate Democrats are objecting to the very reasonable proposal that was done during the Clinton trial of starting with opening arguments, then having questions from the senators, and then having the Senate choose whether additional witnesses are necessary. We've seen one motion after the other. They've been redundant. They've been making the same arguments. This seems to be a time for Adam Schiff and the House managers to lecture the American people and to attack the president. But, you know, there's an old saying that if you have the facts, you bang the facts. If you have the law, you bang the law. If you don't have either, you bang the table. Well, this afternoon we've seen a whole lot of table banging. And at the end of the day, we're in the same spot we were in when we began the day, which is the House articles of impeachment that were passed on a partisan basis. They don't meet the constitutional standard. And that's why the end of this process, after a fair proceeding, after hearing the arguments of the House managers, after hearing the arguments of the president, the end of this proceeding is going to be an acquittal because the House managers still can't meet the constitutional threshold.
Senator, there were some changes made to the initial McConnell resolution based on some concerns from some of your colleagues. Are you concerned that maybe that signals there might not be unity as you get to the witnesses and documents questions?
No, I actually don't at all. So, for example, one of the elements of the original organizing resolution for the Clinton trial was that each side would have 24 hours. The resolution that we're going to vote on later tonight provides each side has 24 hours for their opening arguments. This particular version said those 24 hours would be over 2 days. And so we saw Democrats lighting their hair on fire, that this is an outrageous effort, a cover-up, to have 24 hours of argument over 2 days. God help us if we have to listen to Adam Schiff and the House Democrats prattle on for 24 hours nonstop. But you know what? I think Senate Republicans did something wise and right, which is say, okay, we'll make a concession. Instead of over 2 days, now it's over 3 days. So you can present your opening arguments instead of up to 12 hours a day for 2 days. You can do it presumably for up to 8 hours a day over 3 days. I promise you, if we are at hour 23 and the House Democrats are still repeating the same partisan attacks against the president, you know, it was striking. Within about 3 hours of these proceedings beginning, I looked up, the press corps was about half empty, and the gallery was almost entirely empty. I have to admit, practically a routine motion naming a post office typically has more people in the gallery than we had today, and I think this is indicative of Senate Republicans giving the House Republicans, or the House Democrats, all the opportunity they would like to present their case, but at the end of the day, it's still not going to meet the legal standard.
Senator, given the redundancy you talked about, do you anticipate the White House will offer a motion to dismiss tomorrow, as is the right under the rules?
I don't. I don't think we're going to see a dismissal, and I think a dismissal is not nearly as good an outcome for the president and for the country as will be a final judgment on the merits. I think what's going to happen, we're going to proceed according to the organizing resolution. We're going to give each side up to 24 hours to present their case. We're going to have up to 16 hours of questions from senators, and then we'll have a vote on whether additional witnesses, additional documents are necessary. If the vote is yes, then this trial could extend for many weeks or even months. If the vote is no, then what I think is likely is that the Senate will vote to move to final judgment, and it will end with an acquittal, with each senator standing and voting guilty or not guilty. And the reason the president is going to be acquitted of these charges is the Constitution lays out a very specific standard for impeachment. Impeachment is not, do you disagree with the president? Do you dislike the president? Do you have political differences with the president? Impeachment of a president is only allowed if you demonstrate that the president has committed treason, bribery, or other high crimes and misdemeanors. And you saw very little today about satisfying that constitutional standard from the House managers. You saw a lot of arguments about how House Democrats disagree with the president politically, but that's not the legal standard. Rather, it's the constitutional standard. And so I think the judgment here is not going to be a dismissal, but rather an acquittal on the merits at the end of both sides having an opportunity to present their case.
What can you say about Leader McConnell's approach to overseeing this process and keeping the conference together?
Look, I think it has been good to see Republicans united. I think it has been good to lay out a process that is copied from how the Bill Clinton impeachment trial proceeded, and that was unanimous. The party that I think is being quite unreasonable on this are Senate Democrats. They're not agreeing to the same procedures that every Republican and every Democrat agreed to with Bill Clinton. And listen, that's a manifestation of the times we're in today. The times we're in today, they're angry, they're partisan. I got to tell you, when I go home to Texas, in my experience, Texans and people outside the Beltway, they're tired of this never-ending partisan impeachment drama, these attacks on the president. Texans that I talk to are interested in jobs and higher wages, in more opportunity. Texans are interested in securing the border and rebuilding our military and defending our nation and defending our constitutional rights. That's what we ought to be focused on. But today's House Democrats and Senate Democrats, their only priority seems to be partisan attacks on the president. To make reference to another time and another organization, I think it's time to move on.
Republican Senator Ted Cruz.
On that question of whether there should be more witnesses or you would like to hear from more witnesses, are you a yes or a no on that question right now?
Listen, I think the House had an obligation to develop their case, and I think they failed miserably. Now, they heard from 17 witnesses in the House, but it was really striking. Let's take John Bolton. There's been a lot of discussion about John Bolton. Some of the most important argument we heard this afternoon concerned the testimony of John Bolton, which is that House Democrats asked John Bolton to testify before the House. And John Bolton and his deputy, Charles Kupperman, they did something fairly unusual. They went to a federal court. They went to a district judge, and they said, listen, we have two conflicting legal obligations. We have a request from the House to testify, and we have an instruction not to testify because of executive privilege. And John Bolton and Charles Kupperman both said, Judge, you tell me what to do, and I'll follow your instructions. The House Democrats withdrew the subpoena rather than...
That's Senator Ted Cruz, Republican from Texas, with reporters earlier today. Back live to the Senate floor as they are now resuming after recess and taking up Senator Chuck Schumer's amendment to subpoena the acting White House Chief of Staff, Mick Mulvaney.
The amendment. Thank you. Mr. Cipollone? Okay. Mr. Schiff, the managers will go first and able to reserve time for rebuttal.
That's Chief Justice John Roberts in the chair. And first up, House Impeachment Manager, Congressman Hakeem Jeffries, Democrat from New York.
Mr. Chief Justice, distinguished members of the Senate, Counsel for the President. My name is Hakeem Jeffries, and I have the honor of representing the 8th Congressional District of New York in Brooklyn and Queens. It is one of the most diverse districts in the nation. In fact, I've been told that I have the 9th most African American district in the country and the 16th most Jewish. And here on the Hill, some folks have said, Hakeem, is that complicated? But as my friend Leon Goldenberg says back at home, Hakeem, you've got the best of both worlds. You see, in America, our diversity is a strength. It is not a weakness. And one of the things that binds us together, all of us as Americans, regardless of race, regardless of religion, regardless of region, regardless of sexual orientation, regardless of gender, is that we believe in the rule of law and the importance of a fair trial. The House managers strongly support this amendment to subpoena witness testimony, including with respect to Mick Mulvaney. Who has ever heard of a trial with no witnesses? But that is exactly what some are contemplating here today. This amendment would address that fundamental flaw. It would ensure that the trial includes testimony from a key witness, the President's acting Chief of Staff and head of the Office of Management and Budget, Mick Mulvaney. And it would ensure that the Senate can consider his testimony immediately. Let's discuss why the need to hear from Mick Mulvaney is so critical. First, Leader McConnell's resolution undercuts more than 200 years of Senate impeachment trial practice. It departs from every impeachment trial conducted to date and goes against the Senate's own long-standing impeachment rules, which contemplates the possibility of new witness testimony. In fact, it departs from any criminal or civil trial procedure in America. Why should this president be held to a different standard? Second, the proposed amendment for witness testimony is necessary in light of the president's determined effort to bury the evidence and cover up his corrupt abuse of power. The House tried to get Mr. Mulvaney's testimony. We subpoenaed him. Mr. Mulvaney, together with other key witnesses, National Security Advisor John Bolton, Senior White House aide Robert Blair, Office of Management and Budget official Michael Duffy, and National Security Council lawyer John Eisenberg, were called to testify before the House as part of this impeachment inquiry. But President Trump was determined to hide from the American people what they had to say. The president directed the entire executive branch and all of his top aides and advisors to defy all requests for their testimony. That cannot be allowed to stand. Third, Mr. Mulvaney is a highly relevant witness to the events at issue in this trial. Mr. Mulvaney was at the center of every stage of the president's substantial pressure campaign against Ukraine. Based on the extensive evidence the House did obtain, it is clear that Mulvaney was crucial in planning the scheme, executing its implementation, and carrying out the cover-up. Emails and witness testimony show that Mr. Mulvaney was in the loop on the president's decision to explicitly condition a White House meeting on Ukraine's announcement of investigations beneficial to the president's re-election prospects. He was closely involved in implementing the president's hold on the security assistance and subsequently admitted that the funds were being withheld to put pressure on Ukraine to conduct one of the phony political investigations that the president wanted. Phony political investigations. A trial would not be complete without the testimony of Mick Mulvaney. Make no mistake, the evidentiary record that we have built is powerful and can clearly establish the president's guilt on both of the articles of impeachment. But it is hardly complete. The record comes to you without the testimony of Mr. Mulvaney and other important witnesses. And that brings me to one final preliminary observation. The American people agree that there cannot be a fair trial without hearing from witnesses who have relevant information to provide. The Constitution, our democracy, the Senate, the President, and most importantly, the American people deserve a fair trial. A fair trial requires witnesses in order to provide the truth, the whole truth, and nothing but the truth. That is why this amendment should be adopted. Before we discuss Mr. Mulvaney's knowledge of the president's geopolitical shakedown, it is important to note that an impeachment trial without witnesses would be a stunning departure from this institution's past practice. This distinguished body has conducted 15 impeachment trials. All have included witnesses. Sometimes those trials included just a handful of witnesses, as indicated on the screen. At other times, they included dozens. In one case, there were over 100 different witnesses. As the slide shows, the average number of witnesses to appear at a Senate impeachment trial is 33. And in at least 3 of those instances, including the impeachment of Bill Clinton, witnesses appeared before the Senate who had not previously appeared before the House. That's because the Senate, this great institution, has always taken its responsibility to administer a fair trial seriously. The Senate has always taken its duty to obtain evidence, including witness testimony, seriously. The Senate has always taken its obligation to evaluate the president's conduct based on a full body of available information seriously. This is the only way to ensure fundamental fairness for everyone involved. Respectfully, it is important to honor that unbroken precedent today, so that Mr. Mulvaney's testimony, without fear or favor as to what he might say, can inform this distinguished body of Americans. This amendment is also important to counter the president's determination to bury the evidence of his high crimes and misdemeanors. As we've explained in detail today, despite considerable efforts by the House to obtain relevant documents and testimony, President Trump has directed the entire executive branch to execute a cover-up. He has ordered the entire administration to ignore the powers of Congress, a separate and co-equal branch of government, to investigate his offenses in a manner that is unprecedented in American history. There were 71 requests by the House for relevant evidence. In response, the White House produced 0 documents in this impeachment inquiry. 71 requests, 0 documents. President Trump is personally responsible for depriving the Senate of information important to consider in this trial. This point cannot be overstated. When faced with a congressional impeachment inquiry, a process expressly set forth by the framers of the Constitution in Article 1, the president refused to comply in any respect. And he ordered his senior aides to fall in line. As shown on the slide, as a result of President Trump's obstruction, 12 key witnesses, including Mr. Mulvaney, refused to appear for testimony in the House's impeachment inquiry. No one has heard what they have to say. These witnesses include central figures in the abuse of power charged in Article 1. What is the president hiding? Equally troublesome, President Trump and his administration did not make any legitimate attempts to reach a reasonable accommodation with the House or compromise regarding any document requests or witness subpoenas. Why? Because President Donald John Trump wasn't interested in cooperating. He was plotting a cover-up. It is important to take a step back and think about what President Trump is doing. Complete and total presidential obstruction is unprecedented in American history. Even President Nixon, whose articles of impeachment included obstruction of Congress, did not block key White House aides from testifying in front of Congress during the Senate Watergate hearings. In fact, he publicly urged White House aides to testify. Remember all of those witnesses who came in front of this body? Take a look at the screen. John Dean, the former White House counsel, testified for multiple days pursuant to a subpoena. H.R. Haldeman, President Nixon's former chief of staff, was subpoenaed and testified. Alexander Butterfield, the White House official who revealed the existence of the tapes, testified publicly before the Senate. And so did several others. President Trump's complete and total obstruction makes Richard Nixon look like a choir boy. 2 other presidents have been tried before the Senate. How did they conduct themselves? William Jefferson Clinton and Andrew Johnson did not block any witnesses from participating in the Senate trial. President Trump, by contrast, refuses to permit relevant witnesses from testifying to this very day. Many of President Clinton's White House aides testified in front of Congress, even before the commencement of formal impeachment proceedings. During various investigations in the mid-1990s, the House and Senate heard from more than 24 White House aides, including the White House counsel, the former chief of staff, and multiple senior advisors to President Clinton.
House Impeachment Manager Hakeem Jeffries, live coverage, C-SPAN Radio.
President Clinton himself gave testimony on camera and under oath. He also allowed his most senior advisors, including multiple chiefs of staff and White House counsels, to testify in the investigation that led to his impeachment. And as you can see in the chart, their testimony was packaged and delivered to the Senate. There were no missing witnesses who had defied subpoenas. No aides who had personal knowledge of his misconduct were directed to stay silent by President Clinton. We have an entirely different situation in this case. Here we are seeking witnesses the president has blocked from testifying before the House. Apparently, President Trump thinks that he can do what no other president before him has attempted to do in such a brazen fashion: float above the law and hide the truth from the American people. That cannot be allowed to stand. Let me now address some bedrock principles about Congress's authority to conduct investigations. Our broad powers of inquiry are at their strongest during an impeachment proceeding, when the House and Senate exercise responsibilities expressly set forth in Article 1 of the Constitution. Nearly 140 years ago, the Supreme Court recognized that when the House or Senate is determining a question of impeachment, there is no reason to doubt the right to compel the attendance of witnesses and their answer to proper questions in the same manner and by the use of the same means that courts of justice can in like cases. Our nation's founders and greatest legal minds recognized these principles early on. Supreme Court Justice Joseph Story explained that the president should not have the power of preventing a thorough investigation of his conduct or of securing himself against the disgrace of a public conviction by impeachment if he should deserve it. President Trump cannot function as judge, jury, and executioner of our democracy. And it wasn't just the courts who confirmed this for us. Some of our nation's leading public servants. Representative John Quincy Adams, speaking on the floor of the House after he had served as president, once exclaimed, "What mockery would it be for the Constitution of the United States to say that the House should have the power of impeachment, extending even to the President of the United States himself, and yet to say that the House had not the power to obtain the evidence and proofs on which their impeachment was based." As Hamilton, Story, Adams, and others have recognized, the President cannot insulate himself from Congress's investigations of his wrongdoing. The President could decide what evidence gets to be presented in his own trial that would fundamentally nullify the constitutional power of impeachment. This amendment is important because President Trump simply cannot be allowed to hide the truth. No other president has done it. The Supreme Court does not allow it, and the President is not above the law. Witnesses matter. Documents matter. Evidence matters. The truth matters. Let me now turn to a third justification for this amendment. Mr. Mulvaney's testimony is critical to considering the case for removal. It is imperative that we hear from the President's closest aide, a man intimately involved at key stages of this extraordinary abuse of power. President Trump knows this. Why else would he be trying so hard to prevent Mick Mulvaney from testifying before you? There are at least 4 reasons why Mr. Mulvaney's testimony is critical. To begin with, as acting White House Chief of Staff and head of the Office of Management and Budget, Mick Mulvaney has firsthand knowledge about President Trump's efforts to shake down Ukraine and pressure its new president into announcing phony investigations. Mr. Mulvaney was in the loop at each critical stage of President Trump's scheme. He was in the loop in the planning of the scheme. He was in the loop in its implementation. And he was in the loop when the scheme fell apart. He even admitted publicly that the aid was withheld in order to pressure Ukraine into announcing an investigation designed to elevate the president's political standing. Mr. Mulvaney, perhaps more than any other administration witness excepting the president, has firsthand insight into the decision to withhold $391 million in military and security aid to a vulnerable Ukraine without justification. Indeed, our investigation revealed that President Trump personally ordered Mr. Mulvaney to execute the freeze in July of 2019. Mr. Mulvaney holds the senior-most staff position at the White House. He is a member of President Trump's cabinet, and he is responsible for President Trump's team at 1600 Pennsylvania Avenue. He remains the director of the Office of Management and Budget, which implemented the hold on the security assistance in violation of the law, as the Government Accountability Office recently concluded. In short, respectfully, the Senate's responsibility to conduct a complete and fair trial demands that Mr. Mulvaney testify. Second, Mr. Mulvaney's testimony is critical because of his knowledge of the planning of President Trump's abuse of power. Ambassador Gordon Sondland, the U.S. ambassador to the European Union, testified that there was a quid pro quo Ambassador Sondland is not a so-called never-Trumper. Mr. Sondland gave $1 million to President Trump's inauguration. He testified that everybody was in the loop and that it was no secret what was going on. In fact, as early as May of 2019, Ambassador Sondland made clear that he was coordinating on Ukraine matters with Mr. Mulvaney. Here is what David Holmes, an official at the U.S. Embassy in Ukraine, had to say on that matter.
Well, Ambassador Sondland's mandate as the accredited ambassador to the European Union did not cover individual member states, let alone non-member countries like Ukraine. He made clear that he had direct and frequent access to President Trump and Chief of Staff Mick Mulvaney, and portrayed himself as the conduit to the President and Mr. Mulvaney for this group.
After the U.S. delegation returned from the inauguration of the new Ukrainian president in April, they were able to secure an Oval Office meeting with President Trump to brief him on their trip, in part because of Ambassador Sondland's connections to Mick Mulvaney. Then, during a June 18, 2019 meeting, Ambassador Sondland informed National Security Council Senior Director Dr. Fiona Hill that he was in charge of Ukraine and that he had been briefing senior White House officials, including Mr. Mulvaney, about his efforts to undertake, as Dr. Hill put it, a domestic political errand in Ukraine. Here is Dr. Hill explaining this herself.
So I was upset with him that he wasn't fully telling us about all of the meetings that he was having. And he said to me, but I'm briefing the President. I'm briefing Chief of Staff Mulvaney. I'm briefing Secretary Pompeo, and I've talked to Ambassador Bolton. Who else do I have to deal with? And the point is we have a robust interagency process that deals with Ukraine. It includes Mr. Holmes. It includes Ambassador Taylor as the chargé in Ukraine. It includes a whole load of other people. But it struck me yesterday when you put up on the screen Ambassador Sondland's emails and who was on these emails, and he said, these are the people who need to know, that he was absolutely right. Because he was being involved in a domestic political errand. And we were being involved in national security foreign policy, and those two things had just diverged.
And there's more. Much more. A month later, President Trump's national security advisor at the time, John Bolton, told Dr. Fiona Hill to tell the National Security Council's lawyers that he was not part of whatever drug deal Sondland and Mulvaney were cooking up. He made that statement after Ambassador Sondland specifically said that he had a deal with Mr. Mulvaney to schedule a White House visit for President Zelensky if Ukraine announced 2 phony investigations involving the Bidens and 2016 election interference investigations that were sought by President Donald John Trump. Here is Dr. Hill's testimony about Sondland describing this drug deal he had with Mulvaney.
And so when I came in, Gordon Sondland was basically saying, well, look, we have a deal here that there will be a meeting. I have a deal here with Chief of Staff Mulvaney. There will be a meeting if the Ukrainians open up or announce these investigations into 2016 in Burisma. And I cut it off immediately there. Because by this point, having heard Mr. Giuliani over and over again on the television and all of the issues that he was asserting, by this point it was clear that Burisma was code for the Bidens, because Giuliani was laying it out there. I could see why Colonel Vindman was alarmed. And he said, this is inappropriate with the National Security Council. We can't be involved in this.
The referenced agreement between Ambassador Sondland and Mick Mulvaney was so upsetting that Dr. Hill reported it to National Security Council legal advisors. Here is the testimony of Dr. Hill explaining these particular concerns.
What did he say?
Yes, but he was making a very strong point that he wanted to know exactly what was being said. And when I came back and related to him, he had some very specific instruction for me. And I'm presuming that that's
what was that specific instruction?
So the specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
Sondland's testimony not only corroborates Dr. Hill's account, he actually says that Mick Mulvaney, the subject of this amendment, who should appear before the Senate if we're going to have a free and fair trial. Sondland says Mick Mulvaney knew all about it.
What I want to ask you about is he makes reference in that drug deal to a drug deal cooked up by you and Mulvaney. It's the reference to Mulvaney that I want to ask you about. You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is, announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
Correct.
The documents also highlight the extensive involvement of Mick Mulvaney in this geopolitical shakedown scheme. Email messages summarized by Ambassador Sondland during his sworn testimony showed that he informed Mr. Mulvaney, as well as Secretary Pompeo and Secretary Perry, of his efforts to persuade President Zelensky to announce the investigations desired by President Trump. For example, as shown on the screen, on July 19th, Ambassador Sondland emailed several top administration officials, including Mr. Mulvaney, stating that he had talked to President Zelensky to help prepare him for a phone call with President Trump. And he reported that President Zelensky planned to assure President Trump that he intends to run a fully transparent investigation and will turn over every stone. Ambassador Sondland made clear in his testimony that he was referring to the Burisma Biden and 2016 election interference investigations that were explicitly mentioned by President Trump on the July 25th phone call.
House Manager Hakeem Jeffries, live coverage.
Ms. Mulvaney wrote in response, I asked NSC to set it up. What exactly did Mr. Mulvaney know about the Ukrainian commitment to turn over every stone? And when did he know it? These and many other questions require answers under oath from Mr. Mulvaney. Mr. Mulvaney is also a central figure with respect to how President Trump implemented this pressure campaign. According to public reports and witness testimony, Mr. Mulvaney was deeply involved with implementing the scheme, including the unlawful White House freeze on $391 million in aid to Ukraine. But this isn't just other people fingering Mr. Mulvaney. Mr. Mulvaney has himself admitted that he was involved.
again, I was involved with the process by which the money was held up temporarily. Okay.
The public reports confirm Mr. Mulvaney's own account that he has information that goes to the heart of this inquiry, specifically related to why the president ordered the hold on aid to Ukraine and kept it in place, despite deep-seated concerns among Trump administration officials. This New York Times article on the screen summarizes an email conversation between Mr. Mulvaney and Robert Blair, a senior administration advisor, on June 27th. When Mr. Mulvaney asked, "Did we ever find out about the money for Ukraine and whether we can hold it back?" What prompted that email? According to public reports, Mr. Mulvaney was on Air Force One. Air Force One with President Trump when he sent it. What other conversations did Mr. Mulvaney have with the president and White House officials about this unlawful freeze? The American people deserve to know. There is other significant evidence concerning Mr. Mulvaney's role in implementing the scheme. According to multiple witnesses, the direction to freeze the security assistance to Ukraine was delivered by Mick Mulvaney himself. Office of Management and Budget official Mark Sandy testified about a July 12th email from Mr. Blair stating that President Trump is directing a hold on military support funding for Ukraine. Was Mr. Blair acting at Mr. Mulvaney's express direction? The members of this distinguished body deserve to know. On July 18th, the hold was announced to the agencies in the administration overseeing Ukraine policy matters. Those present were blindsided by the announcement that the security aid appropriated by this Congress on a bipartisan basis to Ukraine, which is still at war with Russian-backed separatists in the East. They were alarmed that that aid had inexplicably been put on hold. Meanwhile, officials at the Defense Department and within the Office of Management and Budget became increasingly concerned that the hold also violated the law. Their concerns turned out to be accurate. Public reports have indicated that the White House is in possession of early August emails, exchanges between Acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide an explanation for the funds. An explanation, I should note, that they were trying to provide after the president had already ordered the hold. Mr. Mulvaney presumably has answers to these questions. We don't know what those answers are, but he should provide them to this Senate and to the American people. Finally, on October 17th, 2019, at a press briefing at the White House, Mr. Mulvaney left no doubt that President Trump withheld the essential military aid as leverage to try to extract phony political investigations as part of his effort to solicit foreign interference in the 2020 election. This was an extraordinary press conference. Mr. Mulvaney made clear that the president was, in fact, pressuring Ukraine to investigate the conspiracy theory that Ukraine, rather than Russia, had interfered in the 2016 election. A conspiracy theory promoted by none other than the great purveyor of democracy, Vladimir Putin himself. When White House reporters attempted to clarify this acknowledgement of a quid pro quo related to security assistance? Mr. Mulvaney replied, "We do that all the time with foreign policy." I have news for you. Get over it. Let's listen to a portion of that stunning exchange.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely. No question about that. But that's it. And that's why we held up the money. Now, there was a report.
So the demand for an investigation into the Democrats was part of the reason that he ordered to withhold funding to Ukraine.
The look back to what happened in 2016 certainly was part of the thing that he was worried about in corruption with that nation. And that is absolutely appropriate.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happened as well.
We do that all the time with foreign policy. We were holding up money at the same time for the Northern Triangle countries. We were holding up aid at the Northern Triangle countries so that they would change their policies on immigration. By the way, and this speaks to an important point, because I heard this yesterday, and I can never remember the gentleman who testified. Was it McKinney? The guy, is that his name? I don't know him. He testified yesterday. And if you believe the news reports, okay, because we've not seen any transcripts of this. The only transcript I've seen was Sondland's testimony this morning. If you read the news reports and you believe them, what did McKinney say yesterday? Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
In this extraordinary press conference, Mr. Mulvaney spoke with authority and conviction about why President Trump withheld the aid. He did not mince his words, but then following the press conference, he tried to walk back his statements as if he had not said them or had not meant them. We need to hear from Mick Mulvaney directly so he can clarify his true intentions. Now, having gone through the need for the evidence, let's briefly address the president's arguments that he can block this testimony. That argument is not only wrong, it fundamentally undermines our system of checks and balances. Step back for a moment and consider the extraordinary position that President Trump is trying to manufacture for himself. The Department of Justice has already said that the president cannot be indicted or prosecuted in office. As we sit here today, the president has actually filed a brief in the Supreme Court saying he cannot be criminally investigated as well while in the White House. So the Senate and the House are the only check that are left when the president abuses his power, tries to cheat in the next election, undermines our national security, breaks the law in doing so, and then tries to cover it up. This is America. No one is above the law. But if the president is allowed to determine whether he is even investigated by Congress, if he is allowed to decide whether he should comply with lawful subpoenas in connection with an impeachment inquiry or trial, then he is the ultimate arbiter of whether he did anything wrong. That cannot stand. If he can't be indicted, and he can't be impeached, and he can't be removed, then he can't be held accountable. That is inconsistent with the United States Constitution. Now, you will no doubt hear that the reason that the president blocked all of these witnesses, including Mr. Mulvaney, from testifying is because of some lofty concern for the office of the presidency and the preservation of executive privilege. Let's get real. How can blocking witnesses from telling the truth about the president's misconduct help preserve the office of the presidency? This type of blanket obstruction undermines the credibility of the office of the presidency and deals the Constitution a potentially mortal death blow. To be clear, executive privilege does not provide a legally justifiable basis for his complete and total blockage of evidence. In fact, as you heard earlier today, President Trump never even invoked executive privilege, not once. And without ever asserting this privilege, how can you consider his argument in a serious fashion? Instead, speaking through Mr. Cipollone, the distinguished White House counsel, in a letter dated October 8, 2019, President Trump simply decided that he did not want to participate in the investigation into his own wrongdoing. It was a categorical decision not to cooperate without consideration of specific facts or legal arguments. In fact, even the words that President Trump used through his White House counsel were made up. In the letter, Mr. Cipollone referred to so-called executive branch confidentiality interest. But that is not a recognized jurisprudential shield, not a proper assertion of executive privilege. To the extent that there are privilege issues to consider, those can be resolved during the testimony, as they have been for decades. And finally, the president claimed that Mr. Mulvaney could not be compelled to testify because of so-called absolute immunity. But every court to address this legal fiction has rejected it. As the Supreme Court emphatically stated in unanimous fashion in its decision on the Nixon tapes, confidentiality interests of the president must yield to an impeachment inquiry when there is a legitimate need for the information, as there is here today. There can be no doubt that Mr. Mulvaney, as the president's chief of staff and head of the Office of Management and Budget, is uniquely situated to provide this distinguished body with relevant and important information about the charges in the articles of impeachment. The president's obstruction has no basis in law and should yield to this body's co-equal authority to investigate impeachable and corrupt conduct. One final point bears mention. If the president wanted to make witnesses available, even while preserving the limited protections of executive privilege, he can do so. In fact, President Trump expressed his desire for witnesses to testify in the Senate just last month. Let's go to the videotape.
So when it's fair, it will be fair in the Senate. I would love to have Mike Pompeo. I'd love to have Mitch. I'd love to have Rick Perry and many other people testify.
If President Trump has nothing to hide, as he and his advisors repeatedly claim, they should all simply testify in the Senate trial. What is President Donald John Trump hiding from the American people? The Constitution requires a fair trial. Our democracy needs a fair trial. The American people deserve a fair trial. A fair trial means witnesses. A fair trial means documents. A fair trial means a consideration of all of the available evidence. A fair trial means testimony from Mick Mulvaney. Mr. Chief Justice, the House managers reserve the balance of our time.
Mr. Cipollone.
Live coverage on C-SPAN Radio. We just heard from Hakeem Jeffrey, one of the House impeachment managers. They are debating the proposed amendment to subpoena White House Chief of Staff Mick Mulvaney. C-SPAN Radio, WCSPN from Washington.
To the President will make the argument.
Thank you. Counsel.
Mr. Chief Justice, members of the Senate, good evening. My name is Michael Propura. I serve as Deputy Counsel to the President. We strongly oppose the amendment and support the resolution. There is simply no need to alter the process on witnesses and documents from that of the Clinton trial, which was supported by this body 100-0. At its core, this case is very simple and the key facts are undisputed. First, you've seen the transcripts, which the President released transparently, unprecedentedly. There was no quid pro quo for anything. Security assistance funds aren't even mentioned on the call. Second, President Zelensky and the highest-ranking officials in the Ukrainian government repeatedly have said there was no quid pro quo and there was no pressure. Third, the Ukrainians were not even aware of the pause in the aid at the time of the call and weren't aware of it, did not become aware of it until more than a month later. Fourth, the only witnesses in the House record who actually spoke to the President about the aid, Ambassador Sondland and Senator Ron Johnson, say the President was unequivocal in saying there was no quid pro quo. Fifth, and this one's pretty obvious, the aid flowed and President Trump and President Zelensky met without any investigations started or announced. Finally, and I ask that you not lose sight of the big picture here. By providing lethal aid to Ukraine, President Trump has proven himself to be a better friend and ally to Ukraine than his predecessor. The time for the House managers to bring their case is now. They had their chance to develop their evidence before they sent the articles of impeachment to this chamber. This chamber's role is not to do the House's job for it. With that, I yield the balance of my time to Mr. Cipollone.
Thank you, Mr. Chief Justice. Just a couple of observations. First of all, as Mr. Propura said, all we're talking about is when this question is addressed. Under the resolution, that'll be next week. This resolution was accepted 100-0. Some of you were here then, thought it was great. If we keep going like this, it'll be next week. For those of you keeping score at home, they haven't even started yet. We're here today. We came hoping to have a trial. They spent the entire day telling you and the American people that they can't prove their case. I could have told you that in 5 minutes and saved us all a lot of time. They came here talking about the GAO. It's an organization that works for Congress. Do you know who disagrees with the GAO? Don't take it from me. They do. They sent you articles of impeachment that makes no claim of any violation of any law. By the way, you know what also doesn't? You can search high and low on the articles of impeachment. You know what it doesn't say? Quid pro quo. Because there wasn't any. Only in Washington would someone say that it's wrong when you don't spend taxpayer dollars fast enough, even if you spend them on time. Now let's talk about the Judiciary Committee for a second. 2 days in the Judiciary Committee. 2 days. The Judiciary Committee is supposed to be in charge of impeachments. The delivery time for the articles they produced was 33 days. I think this might be the first impeachment in history where the delivery time was longer than the investigation in the Judiciary Committee. They come here and falsely accuse people. Oh, by the way, they falsely accused you. You're on trial now. They falsely accuse people of phony political investigations. Really. Since the House Democrats took over, that's all we've had from them. They've used their office, all the money that the taxpayers send to Washington to pay them, to conduct phony political investigations against the president, against his family, against anyone who knew him. They started impeaching him the minute he was elected. They've weaponized the House of Representatives to investigate incessantly their political opponent. And they come here and make false allegations of phony political investigations. I think the doctors call that projection. It's time for it to end. It's time for someone, for the Senate, to hold them accountable. Think about what they're asking. I said it, they didn't deny it. They're trying to remove President Trump's name from the ballot, and they can't prove their case. They've told you that all day long. Think about what they're asking some of you senators to do. Some of you are running for president. They're asking you to use your office to remove your political opponent from the ballot. That's wrong. That's not in the interest of our country. And to be honest with you, it's not really a show of confidence. So we will, I suppose, have this debate again next week, if we ever get there. It's getting late. I would ask you respectfully if we could simply start. Maybe tomorrow we can start, and they can make their argument, and they can, I guess, make a case that they once called overwhelming. We'll see. But this resolution is right, and it's fair, and it makes sense. You have a right to hear what they have to say before you have to decide these critical issues. That's all this is about. Is it now, or is it a week from now? Seriously. Can we please start? Thank you.
White House Counsel Pat Cipollone.
Mr. Cipollone, is your side complete?
Yes, we are, Mr. Chief Justice.
Thank you. The House managers have 14 minutes remaining.
Live coverage on C-SPAN Radio. Hakeem Jeffries.
Counsel for the President indicated that we have not charged President Trump with a crime. We have charged him with crimes against the United States Constitution, high crimes and misdemeanors. Abuse of power strikes at the very heart of what the framers of the Constitution were concerned about. Betrayal of one's oath of office for personal gain, and the corruption of our democracy. High crimes and misdemeanors. That's what this trial is all about. Now, counsel for the president, again, has declined to address the substantive merits of the amendment that has been offered. Tried to suggest that House Democrats have only been focused on trying to oust President Trump. Nothing can be further from the truth. In the last year, we passed 400 bills sent into this chamber. 275 of those bills are bipartisan in nature, addressing issues like lowering health care costs and prescription drug prices, trying to deal with the gun violence epidemic. We've worked with President Trump on criminal justice reform. I personally worked with him, along with all of you, on the First Step Act. We worked with him on the U.S.-Mexico-Canada trade agreement. We worked with him to fund the government. We don't hate this president, but we love the Constitution. We love America. We love our democracy. That's why we're here today. The question was asked by Mr. Sekulow as he opened before this distinguished body. Why are we here? Let me see if I can just posit an answer to that question. We are here, sir, because President Trump pressured a foreign government to target an American citizen for political and personal gain. We are here, sir, because President Trump solicited foreign interference in the 2020 election and corrupted our democracy. We are here, sir, because President Trump withheld $391 million in military aid from a vulnerable Ukraine without justification in a manner that has been deemed unlawful. We are here, sir, because President Donald Trump elevated his personal political interests and subordinated the national security interests of the United States of America. We are here, sir, because President Trump corruptly abused his power and then he tried to cover it up. And we are here, sir, to follow the facts, apply the law, be guided by the Constitution, and present the truth to the American people. That is why we are here, Mr. Sekulow. And if you don't know, now you know. I yield to my distinguished colleague, Chairman Schiff.
House Impeachment Manager Hakeem Jeffries.
I thank the gentleman for yielding, and just want to provide a couple quick fact checks on my colleagues at the other table. First, Mr. Papura said that security assistance funds were not mentioned at all in the July 25th call between President Trump and President Zelensky. Well, let's think back to what was discussed in that call. You might remember from that call that President Zelensky thanks President Trump for the Javelin anti-tank weapons and says they're ready to order some more. And what is President Trump's immediate response? I have a favor to ask, though. What was it about the president of Ukraine bringing up military assistance that triggered the president to go immediately to the favor that he wanted? I think that's telling that it takes place in that part of the conversation. So, yes, security assistance, military assistance did come up in that call. It came up immediately preceding the ask. What kind of message do you think that sends to Ukraine? They're not stupid. The people watching this aren't stupid. Now, Mr. Papura says, well, they never found out about it, or they didn't find out about the freeze in the aid until a month later. Mr. Papura needs to be a little more careful with his facts. Let me tell you about some of the testimony you're going to hear, and you'll only hear it because it took place in the House. If these were other witnesses, you wouldn't be able to hear it. But you had Catherine Croft, a witness from the State Department, a career official at the State Department,
who talked about how quickly, actually, after the freeze went into place, the Ukrainians found out about it, and she started getting contacts from the Ukrainian embassy here in Washington. She said she was really impressed with their diplomatic tradecraft. Now, what does that mean? It means she was really impressed with how quickly the Ukrainians found out about something that the administration was trying to hide from the American people. Ukraine found out about it. In fact, Laura Cooper, a career official at the Defense Department, said that her office started getting inquiries from Ukraine about the issues with the aid on July 25th, the very day of the call. So much for Ukraine not finding out about this for a month later. But I thought this was very telling, too. The New York Times disclosed that by July 30th, so within a week of the call between President Trump and President Zelensky, Ukraine's foreign ministry received a diplomatic cable from its embassy indicating that Trump had frozen the military aid. Within a week, that cable is reported to have gone from the Ukrainian embassy to the Ukrainian foreign ministry. And the former Ukrainian deputy foreign minister, Olena Zerkal, said, quote, "We have this information. It was definitely mentioned that there were some issues." She went on to say that the cable was simultaneously provided to President Zelensky's office. But Andrei Yermak, who you'll learn more about later, a top aide to President Zelensky, reportedly directed her to keep silent and not discuss the hold with reporters or Congress. Now, we heard testimony about why the Ukrainians wanted to keep it secret, that they knew about the hold. You can imagine why. Zelensky didn't want his own people to know that the President of the United States was holding back aid from him. What does that look like for a new president of Ukraine who is trying to make the case that he's going to be able to defend his own country because he has such a great relationship with the great patron, the United States? He didn't want Ukrainians to know about it, but you know, even more than that, he didn't want the Russians to know about it for the reasons we talked about earlier. So yes, the Ukrainians kept it close to the vest. Now, Mr. Popera also went on to say, well, the Ukrainians say they don't feel any pressure. That's what they say now. Of course, we know that's not true. We've had testimony that they didn't want to be used as a political pawn in U.S. domestic politics. They resisted it. You'll hear more testimony about that, about the efforts to push back on this public statement, how they tried to water it down, how they tried to leave out the specifics, and how Giuliani, at the president's behest, forced them to know, no, this isn't going to be credible if you don't add Burisma and you don't add 2016. You'll hear about the pressure. They felt it. So why isn't President Zelensky now saying he was pressured? Well, can you imagine the impact of that? Can you imagine the impact of President Zelensky if he were to acknowledge today, hell yes, we felt pressured. You would too. We're at war with Russia, for crying out loud. Yeah, we felt pressure. We needed those hundreds of millions of military aid, but you think I'm going to say that now? I still can't get in the White House door. They let Lavrov in, the Russian foreign minister, they let him in. I can't even get in the White House door. You think I'm going to go out now and admit to this scheme? I mean, anyone who's watched this president the last 3 years knows how vindictive he can be. Do you think it would be smart for the president of Ukraine to contradict the president of the United States so directly on an issue he's being impeached for? That would be the worst form of malpractice for the new president of Ukraine. We shouldn't be surprised he would deny it. We should be surprised if he were to admit it. Now, let me just end with a couple observations about Mr. Cipollone's comments. He says, this is no big deal. We're not talking about when we're going to have witnesses or if we're going to have witnesses. We're just talking about when. Just talking about when. As if, well, later they're going to say, oh, yes, well, we're happy to have the witnesses now. It's just a question of when. Okay. As my colleague said, let's be real. There will be no when. There will be no when. Do you think they're going to have an epiphany a few days from now and say, okay, we're ready for witnesses? No, their goal is get you to say no now, get you to have the trial, and then argue, make it go away. Let's dismiss the whole thing. That's the plan. A vote to delay is a vote to deny. Let's make no mistake about that. They're not going to have an epiphany a few days from now and suddenly say, okay, the American people do deserve the answers. Their whole goal is that you'll never get to that point. You'll never get to that point. When they say when, they mean never. I yield back.
The majority leader is recognized.
I make a motion to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander.
Aye.
Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Live coverage of the U.S. Senate, C-SPAN Radio.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 53 and the nays are 47. The amendment is tabled.
Mr. Chief Justice.
Mr. Majority Leader is recognized.
I would ask consent to ask the Democratic leader, since there's a certain similarity to all these amendments, whether he might be willing to enter into a consent agreement to stack these votes.
Without objection, the inquiry is permitted.
Thank you, Mr. Chief Justice. The bottom line is very simple. As has been clear to every senator and the country, we believe witnesses and documents are extremely important, and a compelling case has been made for them. We will have votes on all of those. We will also, the leader, without consulting us, made changes, a number of significant changes that significantly deviated from the 1999 Clinton resolution. We want to change those. So there will be a good number of votes. We are willing to do some of those votes tomorrow. There's no reason we have to do them all tonight and inconvenience the Senate and the Chief Justice. But we will not back off on getting votes on all of these amendments, which we regard as extremely significant and important to the country.
As I've
Consent was for a question.
As I've said repeatedly, all of these amendments under the resolution could be dealt with at the appropriate time. I suggest the absence of quorum.
The clerk will call the roll.
Mr. Alexander.
Live coverage on C-SPAN Radio. We are in a simulcast with C-SPAN 2 television. And we'll continue our live coverage throughout the impeachment trial in the U.S. Senate. We heard the majority leader suggest the absence of a quorum. That is usually considered to be a pause as the presiding officer, in essence, takes attendance. But all members of the U.S. Senate, current members of the Senate, are present for this impeachment trial. And again, we will continue our live coverage through gavel to gavel of this impeachment trial.
As Secretary of State, he led the effort on the Paris Climate Agreement, and now John Kerry says it is time to push for world public action to combat what he says is the crisis of our time, climate change. On C-SPAN's podcast, The Weekly, we sit down with President Obama's Secretary of State, the former Massachusetts Senator, and 2004 Democratic presidential nominee.
The Paris Agreement, first of all, again, another lie from Donald Trump, who stood up when he pulled out of the agreement. He said, this places too great a burden on us. No, not true, lie. It doesn't present a burden on us because we wrote the plan.
You can listen to the full interview with former Secretary of State John Kerry on our podcast, The Weekly, available on the free C-SPAN Radio app or wherever you download your favorite podcast. And be sure to follow us on Twitter at C-SPAN Radio.
C-SPAN Radio and a live simulcast with C-SPAN Television.
By the U.S. Senate, and so the Senate in a procedural quorum call, which is essentially a bidding time between a series of amendments being put forth by Senate Democrats, and as you heard in that exchange between Senator McConnell and Senator Schumer, there are more that will be proceeded. A fifth amendment by Senator Schumer trying to force a vote on whether or not the Department of Defense documents and records would be part of the trial, part of the testimony. Previous measures by Senate Democrats have failed, essentially tabled along a party line vote, 53 to 47, 4 of those votes that took place so far today. We should point out that the Chief Justice, John Roberts, who is presiding over this trial, does have work tomorrow morning, the Supreme Court at 10 a.m. tomorrow morning, in a case involving public funding of scholarships to attend religious schools. So the question is how late the Senate will be in session tonight. We heard from Senator Schumer admitting that he does not want to inconvenience the Chief Justice because he is up early tomorrow morning with his day job across the street from the U.S. Capitol on 1st Street Northeast to the U.S. Supreme Court. But right now we'll continue to watch the scene inside the Senate chamber. Again, there is no audio because the audio of the camera is controlled by the U.S. Senate. And as soon as the proceedings continue, we'll continue our live gavel-to-gavel coverage. And a reminder, tomorrow morning at 7 a.m. Eastern Time, a chance for you to weigh in on all of this. The Washington Journal, 4 o'clock for those of you on the West Coast, also carried on C-SPAN Radio. Your reaction to the proceedings today that will likely continue tomorrow. And what we know from the Senate resolution is that there will be 3 days of testimony by the House Democratic managers and then 3 days by the President's defenders and then up to 16 hours of questions by the senators. You see the Chief Justice now standing, a session that was supposed to wrap up earlier but could go well into the evening. We are monitoring all of this, and a reminder being streamed on the web at cspan.org and the free C-SPAN Radio app. Live coverage of the President's impeachment trial in the U.S. Senate from this on Capitol Hill.
Again, C-SPAN Radio and a live simulcast with C-SPAN Television of the Senate impeachment trial. And as we just heard, the audio from the chamber cut off. It's under control of the U.S. Senate, not us at C-SPAN. While we wait for the proceedings to resume, some comments from earlier in the day. This is a news conference held by House Democrats earlier today. These are the House managers in the impeachment trial. And as soon as the proceedings on the Senate floor resume, we'll go there live again here on C-SPAN Radio.
Good morning. Last night we received for the first time the text of the McConnell resolution that will govern the trial. And we could see why this resolution was kept from us and from the American people. This is nothing like the process that was used in the Clinton trial. To begin with, and this is, I think, most indicative, in the Clinton trial, both Senate leadership worked out a bipartisan proposal for how the trial would be conducted. That obviously has not happened here. Senator McConnell did not consult at all with Senator Schumer on the contents of this text. I would imagine that Senator Schumer only got to see it probably at around the same time that we did in the House. And the reason this was kept hidden is that it does not prescribe a process for a fair trial. And the American people desperately want to believe that the Senate will give both the President and the House of Representatives a fair trial. This resembles nothing like the Clinton proceeding. For the first point, in the Clinton case, if we're truly following the Clinton precedent, all of the documents were provided before the trial, more than 90,000 of them. Does this resolution provide for the president to provide the documents before the trial? No, it does not. It leaves that question of whether the House will ever see these documents, whether the American people will ever see these documents, to the end and only the end, with no guarantee that this material will ever be shown to the House or to the American people. That is a profound departure from the Clinton trial. Without the documents, you can't make important judgments about even which witnesses should be called or what questions should be asked of the witnesses when you do. So that is a profound departure from the Clinton precedent. On the subject of witnesses, it is also a deep departure from Clinton, where all of the witnesses testified before the Senate trial. The issue in the Clinton trial was not whether they would testify. They had testified already. They had been interviewed already, some dozens of times.
Into Hawaii.
The question in the Clinton trial was, will they be recalled? Will they be required to testify again? And that question was answered in the affirmative. Here, though, if we're following the Clinton precedent, all of these witnesses should testify, should be deposed before the trial begins, not after the trial is over. So this is not at all the model used in the Clinton case as well.
All we care about is getting rid of the president.
This resolution even goes so far in another departure from the Clinton precedent to say they're not even going to admit the evidence that was received in the House, that they're going to even postpone the decision about whether any of the witness testimony will actually be part of the record. And finally, they are compressing the time of the trial. Whereas the Clinton trial, managers had 6 hours a day to present over a course of days. They're now presenting that we double the amount of time each day so that the proceedings can conceivably go well into the night when apparently Senator McConnell hopes the American people will not be watching. This is not a process for a fair trial. This is the process for a rigged trial. This is the process if you do not want the American people to see the evidence. This is a process you use if you want to, hand in hand, working in concert with the President, allow the President to continue to obstruct the Congress and deny the truth to the American people. Thankfully, however, we know the truth. The evidence is already overwhelming, and that evidence is that the President abused the power of his office, withheld hundreds of millions of dollars of needed military aid to an ally at war in order to coerce that ally into interfering in our election. And then when he was caught, obstructed the Congress to cover it up. That truth is inescapable, no matter how McConnell wishes to structure this trial. But we will be appealing to the manager, we will be appealing as managers to the senators today to live up to the oath they have just taken, to do impartial justice, and to hold a fair trial. And we're happy to respond to questions.
This Democratic News Conference from much earlier in the day. We're going to rejoin C-SPAN 2 television now, as we're going to take some of your comments during this quorum call, this procedural pause in the impeachment trial on the Senate floor.
They don't want to talk about what the president did.
Duties to find out the truth. Our government needs to do that, regardless of if it's the president election or not. So now I am kind of saddened that I have to change parties from being a Democrat to a Republican.
Thomas, thanks for the call from me. We should point out a story that broke a short while ago from the Washington Post. I'll just read the first sentence, but it says several Senate Democrats are privately discussing the possibility of calling the Republicans' bluff on witnesses weighing an unusual trade in the president's impeachment trial, the testimony of Hunter Biden in exchange for key administration officials. That story has been posted online at WashingtonPost.com. Let's go to Andrew, Harrisonburg, Virginia, Republican line. Good evening.
Good evening, Jimmy. I've been watching it on and off all evening. Real interesting stuff going on.
Marcia, you're next from Clarksville, Indiana.
Yes, the only way this trial will be fair to the American people is if all of the documents and testimonies are heard. Anyone who is innocent will want the same because they have nothing to hide. The American people deserve to know because the democracy of our country is at stake.
Marcia, thank you for the call. Miriam is next in Texas, the Democrats line. Good evening.
Yes. I just wanted to say that the Republican senators, we are the ones that are paying them to represent us. We are paying them to give us the truth. They are working for us. They are not working for the president. And all the veterans that are calling in, they are supposed to be representing and protecting the American people. So if a veteran calls in, I would hope that that veteran sticks for the people and they're not there to protect the president.
Miriam, thank you for the call. We'll go next to Pooler, Georgia. Will, Republican line. What have you seen so far today, Will? Hello, you're on the air. We'll try Deanna, who's joining us next from Washington State, Independent line. Same question to you, Deanna. How much have you seen today, and what's your reaction?
Well, I've seen quite a bit today, and what I can say is that there's a lot of deceit happening all over our country, and it's quite disgusting. It's disgusting that our Democrats are accusing our Republicans of the same thing that they're actually doing. It's disgusting that they are such liars. Like, I am an independent, but I'm more of a Republican now because what I can see from them and what the American people can see is deceit. It is vile. I do not understand how they can say the words that come out of their mouth and think that the American people can believe it, because we don't. We're not buying it. We understand that they're liars. They're deceitful. They're accusing a seated president of this same exact thing that they have done over and over
Chief
again.
Justice.
Majority Leader is recognized.
I ask consent that further proceedings on the quorum call be dispensed with.
Without objection, so ordered.
Mr. Chief Justice.
The Democratic Leader is recognized.
I send an amendment to the desk to subpoena certain documents and records from the Department of Defense, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment, number 1288. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution, pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Defense commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of Defense referring or relating to A, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to 1, communications among or between officials at the Department of Defense, White House, Office of Management and Budget, Department of State, or Office of the Vice President. 2, documents, communications, notes, or other records created, sent, or received by the Secretary Mark Esper, Deputy Secretary David Norquist, Undersecretary of Defense Elaine McCusker, and Deputy Assistant Secretary of Defense Laura Cooper or Mr. Eric Tuning. 3, draft or final letters from Deputy Secretary David Norquist to the Office of Management and Budget. And 4, unredacted copies of all documents released in response to the September 25, 2019 Freedom of Information Act request by the Center for Public Integrity, tracking number 19-F-1934. B, the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine, including but not limited to 1. Communications received from the Department of State concerning the Ukrainian embassy's inquiries about United States foreign assistance, military assistance, and security assistance to Ukraine, and 2. Communications received directly from the Ukrainian embassy about United States foreign assistance, military assistance, and security assistance to Ukraine. C. Communications, opinions, advice, counsel, approvals, or concurrences provided by the Department of Defense, Office of Management and Budget, or the White House on the legality of any suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, and security assistance to Ukraine. D. Planned or actual meetings with President Trump related to United States foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to any talking points and notes for Secretary Mark Esper's planned or actual meetings with President Trump on August 16, August 19, or August 30, 2019. E. The decision announced on or about September 11, 2019 to release appropriated foreign assistance, military assistance, and security assistance to Ukraine, including but not limited to any notes, memoranda, documentation, or correspondence related to the decision, and F, all meetings and calls between President Trump and the President of Ukraine, including but not limited to documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York, and 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this action.
The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone?
Mr. Chief Justice, we are an opponent.
So, Mr. Schiff, the House managers can proceed first and reserve time for rebuttal.
Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of the counsel for the President. Mr. Chief Justice, Senators, Counsel for the President, and the American people. I'd like to begin by getting something off of my chest, something that's been bothering me for a little while. Counsel for the President and some other folks in this room have been talking a lot about how late it's getting, how long this debate is taking. It's almost 10 p.m. in Washington, D.C. They say, let's get the show on the road. Let's get moving.
Impeachment Manager Jason Crow.
And the whole time, the only thing I can think about is how late it is in other places. Because right now, it's the middle of the night in Europe, where we have over 60,000 U.S. troops. There are helicopter pilots flying training missions, tankers maneuvering across fields, infantrymen walking with 100-pound packs. And yes, Ukrainian soldiers getting ready to wake up in their trenches, facing off against Russian tanks right now. And I don't think any of those folks want to hear us talk about how tired we are or how late it is. We have time to have this debate. And that's why the House managers strongly support this amendment to subpoena key documents from the Department of Defense. Because just like the subpoena for OMB, these documents from DOD speak directly to one of President Trump's abuses. His withholding of critical military aid from our partner Ukraine. to further his personal political campaign. $250 million of taxpayer-funded military aid for Ukraine was managed by the Department of Defense as part of the Ukraine Security Assistance Initiative. These funds, approved by 87 senators in this very room, would purchase additional training, equipment, and advising to strengthen the capacity of Ukraine's armed forces. The equipment approved for Ukraine included sniper rifles, rocket-propelled grenade launchers, counter-artillery radar, night vision goggles, and medical supplies. And this equipment was to be purchased almost exclusively from American businesses. This equipment, along with the training and advising provided by DoD, was intended to protect our national security by helping our friend Ukraine fight against Vladimir Putin's Russia. Earlier, counsel for the president tried to make the argument, well, it made it there. The aid eventually made it there. The delay doesn't really matter. And you heard me talk about why the delay does matter. But what counsel for the president didn't say is that all of the aid has not made it there. Congress had to pass another law so that $35.2 million of that aid wouldn't expire and lapse. We did. But to this day, $18.5 million of that money remains outstanding and hasn't made its way to the battlefield. It was DoD that repeatedly advised the White House and OMB about the importance of the security assistance to not only Ukraine, but also U.S. national security. It was DoD in August of 2019 that warned OMB that the freeze was unlawful and that the funds could be lost as a result. And it was DoD that scrambled after the hold was lifted without explanation on September 11th to spend the funds before they expired at the end of the month. Without a doubt, DoD has key documents that the president has refused to turn over to Congress. Key documents that go to the heart of the ways in which the president abused his power. It's time to subpoena those documents. DoD documents would provide insight into critical aspects of this hold. They would show the decision-making process and motivations behind President Trump's freeze. They would reveal the concerns expressed by DoD and OMB officials that the hold was violating the law. They would reveal our defense officials' grave concerns about the impact of the freeze on Ukraine and U.S. national security. They would show that senior Defense Department officials repeatedly attempted to convince President Trump to release the aid. In short, they would further establish the president's scheme to use our national defense funds to benefit his personal political campaign. We are not speculating about the existence of these documents, and we're not guessing about what they might show, because during the course of the investigation in the House, witnesses who testified before the committees identified multiple documents directly relevant to the impeachment inquiry that DoD continues to withhold. We know these documents exist, and we know that the only reason we do not have them is because the president himself directed the Pentagon not to produce them, because he knows what they would show. To demonstrate the significance of the DoD documents and the value they would provide in this trial, I would like to walk you through some of what we know exists, but that the Trump administration continues to refuse to turn over. And again, based on what is known from the testimony and the few documents that have been obtained through the public reporting and lawsuits, it's clear that the president is trying to hide this evidence because he is afraid of what it would show the American people. We know that DoD has documents that reveal that as early as June, the president was consider holding military aid for Ukraine. As I mentioned earlier, the president began questioning military aid to Ukraine in June of last year. The president's questions came days after DoD issued a press release on June 18th, announcing it would provide its $250 million portion of the aid to Ukraine. According to public reporting, Deputy Undersecretary of Defense Elaine McCusker, who manages the DOD's budget, learned about the president's questions. We know this email exists because in response to a Freedom of Information Act lawsuit, the Trump administration was forced to release a redacted email. But DOD provided none of those documents to the House. Deputy Assistant Secretary of Defense Laura Cooper and her team were tasked by the Secretary of Defense with responding to the President's questions about the Ukraine assistance. Ms. Cooper testified that she put those answers in an email and described those emails during her deposition. She testified that DOD advised the security assistance was crucial for both Ukraine and U.S. national security and had strong bipartisan support in Congress. But DOD provided none of those documents to the House. With this proposed amendment, the Senate has an opportunity to obtain and review the full record that could further demonstrate how and why the President was holding the aid. Laura Cooper also testified about the interagency meetings that occurred in late 2019. The meetings at which DOD was shocked to learn that President Trump had placed a mysterious hold on the security assistance. We know what happened at several of those meetings because Ms. Cooper participated in them, in some cases with other senior Defense Department officials. However, we don't have Laura Cooper's notes from those meetings. We don't have the email she sent to senior DOD officials reporting the stunning news about the President's hold. We don't have the emails that show the response from the Secretary of Defense and other senior defense officials because DOD has refused to provide them. Separately, Laura Cooper testified about when Ukraine first learned of the President's secret hold on the military assistance. The same day as the President's July 25th call with President Zelensky, DOD officials received 2 emails from the State Department indicating that officials from the Ukrainian embassy and congressional staff had become aware of the hold and were starting to ask questions. Ms. Cooper testified that she was informed, quote, the Ukrainian embassy and House Foreign Affairs Committee are asking about the military aid, end quote, and that the Hill knows about the FMS situation to an extent, and so does the Ukrainian embassy. All of this shows that people were starting to get very worried. Again, this amendment for a subpoena to DOD would compel the production of these important documents. But again, there is more. DOD documents would also reveal key facts about what happened on July 25th after OMB directed DOD to, quote, hold off on any additional DOD obligations for the assistance to Ukraine. How did DOD officials react to OMB's directive to keep this order quiet? Did DOD officials raise immediate concerns about the legality of the hold? Concerns that they would eventually vocally articulate to OMB in August. Did DOD officials hear from the American businesses that were on tap to provide the equipment from Ukraine? Was DOD informed that the President's hold would undermine American jobs? Answers to those questions may be found in DOD emails. Emails that we could all see if you issue the subpoena. Earlier, I mentioned that by late July, officials in our government raised significant concerns about the impact and the legality of President Trump's hold on the military aid. We know this from witness testimony, public reporting, and documents produced in Freedom of Information Act lawsuits. For example, at an interagency meeting on July 31st, Laura Cooper, one of the officials at DOD, announced that because there were 2 legally available options to continue the hold, and they did not have direction to pursue either of those legal options, DOD would have to start spending the funds on August 6th. Cooper explained that if they did not start spending the funds, they would risk violating the Impoundment Control Act. It was a fateful warning because that is exactly what happened. Throughout August, Pentagon officials grew increasingly concerned as the hold dragged on. According to public reporting, DoD wrote to OMB on August 9th to say that it could no longer claim the delay would have no effect on the Defense Department's ability to spend the funds. We only know this through recent reporting about the contents of the email. President Trump certainly hasn't made this information public. In response to a Freedom of Information Act request, the Trump administration released this August 9th email from Elaine McCusker, the Pentagon's chief budget officer. And as you can see from the slide in front of you, it is almost entirely blacked out. According to public reporting, the email said, quote, "As we discussed as of 12 August, we don't think we can agree that the pause will not preclude timely execution. We hope it won't, and we'll do all we can to execute once the policy decision is made, but can no longer make that declarative statement." Let me interpret what's actually being said here. What's actually being said is, we're in trouble. We can't spend the money in the time that we have left, and we're not going to cover your tracks anymore and say that we can't. The extensive redactions in the Freedom of Information Act productions highlight the administration's efforts to conceal the president's wrongdoing. They also underscore why the Senate must subpoena DoD documents to ensure that all of the relevant facts come to light. And yes, there is more.
House Manager Jason Crow, WCSP from Washington.
Husker and others at DoD, OMB eventually dropped from the documents the statement that the hold would not preclude timely execution of the funds. But OMB also circulated talking points claiming that, quote, "No action has been taken by OMB that would preclude the obligation of these funds before the end of the fiscal year," end quote. Let me just explain what's going on here. Everybody is getting worried. Everybody knows that something bad is about to happen. Nobody has a good explanation. And nobody wants to be left holding the bag. So they're sending the emails, they're sending the memos to say, "I told you so, and I'm not going to be held responsible." DoD's McCusker took issue with OMB's talking point. She did so in writing. Ms. McCusker emailed Mr. Duffy to tell him that OMB's talking points were, quote, "just not accurate," and that DoD had been consistently conveying that point for weeks. Again, we know this from a press report, not from documents produced to Congress by the Trump administration. Now, President Trump did release some documents in response to a lawsuit under the Freedom of Information Act. But here is what Ms. McCusker's email looked like when it was released by the Trump administration. Her concern that OMB's talking point was, quote, "just not accurate," was again entirely blacked out. What else is being hidden from the American people? The Senate should issue the subpoena. DoD documents would also shed light on OMB's actions as the president's scheme unraveled. On September 9th, Ms. McCusker informed Duffy that DoD could fall short of spending $120 million or more because of the hold. Duffy responded by suggesting that it would be DoD's fault if they ended up violating the Impeachment Control Act. McCusker responded, quote, "You can't be serious. I am speechless," end quote. It will come as no surprise then that the administration entirely redacted this email too when it produced the documents in connection with the Freedom of Information Act lawsuit. Thanks to public reporting, though, we do know its contents. But what else is being hidden from the American people? What other reactions did this exchange set off within DoD? And were those concerns brought back to the White House? The Department of Defense's documents would shed light on these questions. The American people deserve answers. Make no mistake,
The record before the House fully supports the conclusion that President Trump froze vital military aid to pressure Ukraine into helping the president's political campaign. The DoD documents would provide further evidence of this scheme. They would expose the full extent of the truth to Congress and the American people, and they would firmly rebut any notion that President Trump was acting based on concerns about corruption or other countries' contributions. And the president knows it. If there was any doubt, recent events prove that DoD has documents that are directly relevant to this trial. As I spoke about earlier, before I was a member of Congress, I was a soldier in Iraq and Afghanistan. And I do know what it feels like to not have the equipment that you need. The men and women who work at the Department of Defense and administer this vital aid understand that reality too. And that is why they repeatedly made the case to President Trump why military assistance to Ukraine is important. That it would not only help Ukraine, but also bolster our deterrence against further Russian aggression in Europe. Because every time we have these discussions that might seem abstract to people around the country, I do think about those 60,000 U.S. troops that we have in Europe. Many of whom, by the way, are stationed there with their families, their spouses, their children, and how they're training and working every day to hold the line and fight for freedom and liberty in Europe. And if the war in Ukraine spills over outside of Ukraine, it is those men and women that will have to get into their tanks, in their helicopters, and do their job. The United States Senate cannot let this information remain hidden. It goes directly to one of President Trump's abuses of power, again withholding aid that 87 people in this room already voted for. The President, the Senate, and the American people deserve a fair trial. Let's see the documents and let's see them now. And let the facts speak for themselves. I would like to end by reading a short transcript, something that I was thinking about earlier this evening. This is a transcript from Ambassador Taylor's testimony. I just want to take a minute to read it to you. He was talking about a trip that he made to visit our friends in Ukraine. We had a meeting with the defense minister. It was the first meeting of the day. We went over there. They invited us to a ceremony that they have in front of their ministry every day. Every day they have this ceremony. And it's about a half an hour ceremony where soldiers in formation, the defense minister, families of soldiers who have been killed are all there. And the selection of which soldiers are honored, which soldiers who had been killed are honored, is on the date of it. So whatever today's date is, you know. If we were there today on the 22nd of October, the families of those soldiers who were killed on any 22nd of October in the previous 5 years would be there. End quote. Ambassador Taylor was talking about our friends. At least 13,000 of them have given their lives in the last 5 years in the fight for liberty in Europe. This, ladies and gentlemen, is a national disgrace. And only the people in this room can fix it. It's time to issue the subpoenas. Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the President's argument.
House Manager Jason Crow They are debating the Democratic proposed amendment seeking documents and records from the DOD related to the withholding of security funds from the Ukraine.
Chief Justice, members of the Senate, I will be brief. And this may seem like some deja vu all over again because we've been arguing about the same issues really over and over and over for a long time. And I think that's something that Americans one of the things they don't really understand about Washington is how it could be the House Democrats think that it is the best use of time for this body to spend an entire day deciding simply the issue of when this body should decide about whether or not there should be witnesses and documents subpoenaed, because that is the issue before the body now. It is not the question, finally, of whether there should be witnesses or documents. As the majority leader has made clear multiple times, the underlying resolution simply allows that issue to be addressed a week from now.
Deputy Counsel to the President, Patrick Philbin.
The House managers keep saying, how can you have a trial without witnesses? How can you have a trial without documents? That's not even the issue. The issue is only now whether you have to decide that issue to subpoena documents or witnesses now or decide it in a week after you hear the presentations. Why are they so eager to have you buy a pig in a poke? Why is it necessary to make that decision without having more information? In the Clinton trial, this body agreed 100-0 that it made more sense to have more information and then decide how to proceed. That it was rational to have more information to hear the presentations and then decide what more was necessary. Why is it so important that you've got to make that decision now without that information? That doesn't make any sense. The rational thing to do is to hear what sort of case they present and, importantly, to hear the President's defense, because the President had no opportunity in the House to present any defense. We've heard a lot about the rule of law and about precedent. What was unprecedented was the process that was used in the House, a process that began with an impeachment inquiry that started without any vote by the House. And this is a point I made earlier. The Constitution assigns the sole power of impeachment to the House, not to any single member of the House. So the press conference that Speaker Pelosi held on September 24th did not validly initiate an impeachment inquiry, nor did it validly give power to committees to issue subpoenas. So we're talking now about the DOD documents. What efforts did they make in their proceeding to get these documents? They issued one invalid subpoena, totally unauthorized under the Constitution. It was unprecedented because it was issued in an impeachment inquiry, purportedly, without any vote from the House. Never happened before in our history in a presidential impeachment. It was unlawful. It was unauthorized. And that's why no documents were produced, and they made no other efforts to pursue that. So we've heard a lot about the rule of law. The rule of law applies to the House Democrats as well, and they didn't abide by it. It was unprecedented to have a process in which the President had no opportunity to present his defense, no opportunity to present witnesses, no opportunity to be represented by counsel, no opportunity to present evidence whatsoever in 3 rounds of hearings. And they'll mention, in the Judiciary Committee, they were willing to give the President rights. But in the Judiciary Committee, after one hearing, the Speaker announced the conclusion that articles were going to be drafted, and the committee had already decided it would hear no fact witnesses. There were no rights for the President. So it makes sense, what's rational, what 100 senators 21 years ago thought was rational, was to hear the case that can be presented on the record established so far and then decide if something else needs to be done. Let the President make his case. We're ready to get this started. The House managers should be as well. Thank you, Mr. Chief Justice.
Deputy Counsel to the President, Patrick Philbin.
The balance of our time.
Thank you. House managers have 38 minutes remaining.
Democratic Congressman and House Manager Jason Crow.
Counsel for the President continues to say a lot of things that just really rub me the wrong way. He says, we're talking and saying the same argument over and over and over again. Well, I'm ready to keep going because this is an important debate and we need to have it now. He also said something about what the American people don't understand about Washington. Well, I haven't been here very long, and I can tell you I don't think the American people care very much about whether or not people in Washington, are sitting around debating all the time and thinking about, what you're concerned about right now. What they are concerned about is whether or not their government is working for them, whether or not there's corruption in their government. That's what they understand, and that's what this debate is about. Counsel for the President said, why now? Why the information now? The better question is, why not now? This trial has started. Let's have the facts and information now. Ladies and gentlemen, the time is right. There's no reason why we shouldn't issue those subpoenas, get the facts, get the testimony, have the debate, let the American people see what's really going on here. Mr. Chief Justice, I will yield the balance of my time to Mr. Schiff.
Thank you.
Senators, I'll be brief, but I do want to respond to a couple of the points that my colleagues have made. First is the argument that you've heard before, and I have no doubt you'll hear again, that the subpoenas issued by the House are invalid. Well, that's really wonderful. I imagine when you issue subpoenas, they will declare yours invalid as well. What's the basis of the claim they're invalid? Well, because they weren't issued the way the President wants. Part of the argument is you have to issue a subpoena the way we say, and that can only be done after there is a resolution that we approve of adopted by the full House. First, they complained there was no resolution, no formal resolution of the impeachment inquiry, and then when we passed a formal resolution, they complained about that. They complained when we didn't have one, they complained when we did have one. Well, they made that argument already in court, and they lost. In the McGahn case, they similarly argued this subpoena for Mr. McGahn is invalid. And you know what the judge said? Essentially, that's nonsense. The President doesn't get to decide how the House conducts an impeachment proceeding. The President doesn't get to decide whether a subpoena it issues is valid or invalid. No, the House gets to decide, because the House is given the sole power of impeachment, not the President of the United States. Now, counsel says, why are we going through all these documents? Aren't all these motions the same? And the fact of the matter is, we're not talking about the same documents here. They would like nothing better than for you to know nothing about the documents we seek. They don't want you to know what Defense Department documents they're withholding. Yeah, of course they don't want to hear that. They don't want you to know what State Department documents are they, because if it's just abstract, if it's just we're here arguing for documents, well, they can say, well, that's really not that important, right? It's just some generic thing. But when you learn, as you have learned today and tonight, what those documents are, when you see the efforts to conceal those Freedom of Information Act emails that my colleague Mr. Crow just referred to, and you see what was released to the public, and it's all redacted, and we find out what's under those redactions, and wow, surprise, it's incriminating information they have redacted out. That is not supposed to be the basis for redaction under the Freedom of Information Act. That's what we call a cover-up. They didn't want you to see that today. They didn't want you to see the before and the after, the redacted and the non-redacted. They didn't want you to hear from these witnesses about the detailed personal notes that they took. Ambassador Taylor took detailed personal notes. Now, They want to try to contest what Ambassador Sondland said about his conversations with the president. Because Sondland, after he talked with the president, talked directly with Ambassador Taylor and talked directly with Mr. Morrison and explained his conversation with the president. Well, guess what? Mr. Morrison and Ambassador Taylor took detailed notes. There's a dispute about what the president told Mr. Sondland. Wouldn't you like to see the notes? They don't want you to know the notes exist. They don't want to have this debate. They'd rather just argue, no, it's just about documents. It's just about when. We want the senators after 16 hours of questions before they can see any of this stuff. And you know what? Then we're going to move to dismiss the case. The when, as I said earlier, means never. And finally, the Clinton precedent. President Clinton turned over 90,000 pages of documents before the trial. I agree. Let's follow the Clinton precedent. It's not even going to take 90,000 documents. The documents are already collected. You heard the testimony on the screen of Ambassador Taylor saying, oh, they're going to be turned over shortly. Well, we're still waiting. But they're still sitting there at the State Department. We didn't play a video for you of Secretary Esper on one of the Sunday shows saying, we're going to comply with these subpoenas. Well, that was 1 week. And then somebody got to him, and all of a sudden he was singing a different tune. Yeah, they don't want you to know what these documents hold. And yes, we're showing you what these witnesses can tell you. We're showing you what Mulvaney could tell you. And yeah, we're making it hard for you. We're making it hard for you to say no. We're making it hard for you to say, I don't want to hear from these people. I don't want to see these documents. We're making it hard. It's not our job to make it easy for you. It's our job to make it hard to deprive the American people of a fair trial. And that's why we're taking the time to do it. I yield back.
The majority leader is
Mr.
recognized.
Chief Justice, I make a motion to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
Are there any senators in the chamber who wish to change his or her vote? If not, the yeas are 53 and the nays are 47. The amendment is tabled.
Mr. Chief Justice.
The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to issue subpoenas to Robert B. Blair and Michael P. Duffy, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1289. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution, pursuant to Rules 5 and 6 of the Rules of Procedure and Practice, in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States through the Secretary of the Senate shall A, issue a subpoena for the taking of testimony of Robert B. Blair, and B, issue a subpoena for the taking of testimony of Michael P. Duffy, and 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone? Mr. Schiff, the House managers can then proceed and reserve time for rebuttal.
Mr. Chief Justice, Senators, Counsel for the President. My name is Sylvia Garcia, and I am a Congresswoman from Texas in the Houston region. You know, I've been sitting for some time, as well as you, and it brought to mind the many years that I spent as a judge. Justice, all of you today are judges in this hearing. It's important that I say a few words before I start our argument for this amendment, because in the scheme of things, it's really not that very complicated. The American people, everyday Americans, know what a trial looks like, whether they've seen it on Perry Mason or Law and Order, or maybe they've been in court themselves. They know what a trial is. It's about making sure that people have an opportunity to be heard, both sides. It's about witnesses. It's about documents. It's about getting a fair shot. And that's all that we're asking for today, is to make sure that we give the American people the trial that they expect, to make sure that the American people know that this president needs to be held accountable. Because if it were they who were accused or alleged to have done something, they would want the same thing. So for me, it's about making sure that we get a fair trial, which is why I'm here representing the House managers to strongly support this amendment to subpoena Robert Blair and Michael Duffy. Blair and Duffy are the two officials who carried out President Trump's order to freeze vital military aid to Ukraine. Their testimony would shed light on central facts the House uncovered in our impeachment inquiry. Their testimony will further affirm that President Trump had no legitimate policy reason for the order. Blair works in the White House as the senior advisor to the acting chief of staff, Mick Mulvaney. Duffy is a political appointee. He works in the Office of Management and Budget. There he serves as the Associate Director for National Security Programs. Both were subpoenaed by the House investigative committees. Both were ordered not to appear, so both failed to appear for their scheduled depositions. Despite repeated outreach and despite their legal duty to comply, Blair and Duffy are not household names. Many Americans have never heard of them, but they operated the machinery of the executive branch. They implemented President Trump's instruction to freeze military aid to Ukraine. They communicated about the freeze with each other, with Mulvaney, with OMB's acting director Russell Vought, and with numerous officials at the State Department and the Department of Defense. They stood at the center of this tangled web. Some of their communications are known to us from the testimony of other witnesses before House committees. Other communications have been revealed through public reporting and the Freedom of Information Act releases. But these communications only partly penetrate the secrecy in which President Trump sought to cloak his instruction to freeze military aid to a vulnerable strategic partner. As plentiful evidence confirms, officials throughout the government were stumped, literally stumped, about why the freeze was happening. They were thwarted when they tried to get explanations from Blair and Duffy. Consistent with President Trump's effort to hide all evidence, Blair and Duffy have defied the House's subpoenas at the President's direction. To explain why this amendment should be passed,